cool. I think we're in business. Think we are in business. Cool. I think we're in business. There is. All right, cool. Sheesh. I just looked away and the whole room is packed. Goddamn. Hey, what's going on, everyone? Rodney, what's good? What's good? What's good? What's good? I literally just looked away for 2 seconds. All right. So, y'all know there's some new stuff coming out, right? There's some new laws. New York, for one. New York has done something truly amazing, and we're going to go over it today. We're going to go over really 4 things. And these 4 things are every law that that gets put out in where consumer law is concerned, it affects the credit industry. That's number 1. So it's important. Oh, you know what? I was supposed to start the Zoom because I'm going to record this and I will have it in the university for the students to always refer to. So let me set up this Zoom real quick and get that going. But as it relates to any law in any industry that you're in, it's important that if you are a subject matter expert, right? I'm not saying you should be out in these streets calling yourself a guru, but if you're in these streets and one second, let me get this Zoom up and going. If you're in these streets, whether you call yourself a credit repair expert.
Recording in progress.
Okay. Got it. Just give me 2 seconds. Let me just get this up and going. So, for those of you who don't know, we're in my birth month. My birthday is April 6th. I'm going to let y'all know. My birthday is April 6th. So if you're any subject matter expert and you are in a field, it's important that you keep abreast of all the information that's going on. So let me share screen here and just let me get that set up so when I start, I just go all in. All right, cool. So for those of you who don't know, so this is white Henny. I went to Jamaica and I brought myself up a bottle, so I will be partaking in this on the live. Pinkies up, pinkies up. So we're gonna have a great time today. My biggest thing is just come with an open mind because you're gonna learn a lot. You're definitely gonna learn a lot. So yeah, let's get into it. All right. Now, a lot of you might know or might have heard that medical collections will soon fall off. Thank you for sharing your help us clean off my credit score and raise my credit score. Ooh, shout out to Melissa. All right, we got a testimony on YouTube, guys. Let me break for a quick second. Melissa Lee at Doreen Levante, thank you for all your sharing to help us. My 588 score, clean off my credit reports and raise my credit score up to 750 in the next 30 to 60 days at best. Can disputing consumer file get? Oh yeah, I'm a little confused with that on my scores. Clean up, boom, boom, boom. Okay. So as it relates to your consumer reports, any item on it can be deleted. It doesn't matter what account it is. So I'm not going to be doing a lot of questions today. Today is going to be more of a lecture, right? Had fear to lose. Today's going to be more of a lecture. So today I want y'all to be taking notes. Like I said, I won't be taking any a lot of questions until probably like the end. Today is really about lecture, about giving y'all the information that's going on in the industry. So I'm not going to break to look and read questions on this. This is a lecture. I want y'all to get your books, your pens, your notepads, whatever, get your drink ready, because today we're really going to go into a lot of stuff. And I got a big announcement, and we're in my birthday month. So April 6th is my birthday because I'm an island boy. All right. So, yeah. All right, cool. So, without further ado, ladies and gentlemen, let's get into it. So now, new rules. So this just came out. I got this info from one of my mentees, and it's great that when you build a community where a lot of people are able to, oh, and by the way, I'm giving away a free masterclass. I'm giving away a free masterclass. I'm going to say this again. I am giving away a free masterclass to help with the comprehension of the new FDCPA rules. So as soon as my assistants, as soon as they come in and my team members come in, we'll get the links and everything going, and we will be able to get you all that information. So I'm going to be giving away a free masterclass, a new rule FDCPA overview for y'all to study with. All right. So I'll be doing that very, very soon. So as soon as my team members come in and they're able to get everything up and going, we'll be able to have those text alerts for you to use, for you to get the notification for the free training. You watch it on your own time. It's completely free. It's for you. Take it, learn it. It's the new FDCPA rule. And like my mentor, Myron Golden, says, if you can't give your best for free, you don't know enough. So I'm definitely giving away this masterclass for free. So as soon as the team comes in and we set everything up, they will be putting that information out. All right. So you're going to see Boss Mom Talks by Nish, and you're going to see a bear. You're going to see both of them, and they will be communicating through me, through YouTube, IG, Clubhouse, and this recording that I'm making right now. I might have a beer stream it to Facebook. I don't know yet. Yeah, I probably shouldn't I? Nish, could you get in touch with a beer and have her stream this live into Facebook? I'm going to take your silence as a yes. All right, cool. So, yeah, just have a beer stream this into Facebook, and then when we're finished, I'll get the recording and I'll put it in the university. So, all right. For those of you who are just joining, who has no idea who I am, my name is Durain Delavante. I am your favorite consumer law expert, and I am here to give you all the sauce as it relates to consumer laws, how to use consumer laws to repair, rebuild, restore your own credit. You can get paid for having bad credit by finding your consumer law violations, interpretation, analysis, and real overview of what words mean and breaking their words down so you can use it against them. Because remember, if you use their own words against them, they can't come back and say, well, we didn't say that. Well, it's your words. You can't go back on your own words. That is fraud, all right? So what we teach here in the Consumer Law Secrets University is basically how to equip you with the right information, right? So if you're on Clubhouse, you're going to see that link at the top. You're going to see that link at the top Pin, comment. Okay, boom. You're going to see that link at the top where you're able to get access to that free training. If you're on Instagram, right? If you text FDCPA to 74121, you will get access to the link. So right now, if you text FDCPA to 74121, you will receive the link. All right? Shout out to Mama T from Abu Dhabi. Shout out to the family that's there in Dubai. They're traveling. They're doing great. I can't wait to see y'all in 2 weeks when I'm in Atlanta. It's going to be amazing. So YouTube, you have it as well. So if you text FDCPA to 74121, it's going to give you access to the free new FDCPA rules masterclass that I did with one of my mentorship group. All right. So same thing for Instagram, same thing for Clubhouse. You can text it or just hit the link at the top. It's going to give you access to that free training. All right. Boom. So that's pinned. That's pinned. This is pinned. A bear, I don't see you on Clubhouse, but if you're hearing me, let's stream the Zoom into Facebook. So let's stream the Zoom into Facebook and let's get into it. So new debt collection law goes in effect next month. Now, this article is dated as of March 30th, 2022, 11:10 a.m. So what this simply means is April, which is tomorrow, right? April, there's going to be a new law, and I'm going to get into that now. So it's short and spicy. So let me give you all a breakdown of what's going on. All right. So Albany, New York Attorney General Lilita James recently sent letters to the largest credit card companies and major debt collectors operating in New York. So from what I'm getting, this law, or should I say, the Attorney General for New York, she's making changes to debt collection on debt collection companies, debt buyers, whatever, who operate in the state of New York. So if they're going to come in the state of New York to collect or to attempt to collect any debt, our Attorney General, right, has some news for you. So for people in New York right now, y'all should be smiling. All right, so let's get into it. So basically, she is warning them, right, of new state regulations that prevent them from suing for old debts. A new law protecting debtors goes into effect in April. Like, do y'all drop some fire in the chat for New York State Attorney General Lilita James? Let me see some fire in the chat right now. Let me see some fire in the chat. If you're in Clubhouse, blink your mic, take a sip. I don't know. But let me see some fire right now. And I want each of y'all to write your attorney generals. Write them and have them do what New York is doing. Write your state attorney generals and have them do what New York is doing. So let's get into it. I'm going to read that first part again. This is coming out of Albany. The New York Attorney General, Lilita James, recently sent letters to the largest credit card companies and major debt collectors operating in New York, warning them of the new state regulations that prevent them from suing consumers for old debts, right? This is a major win. Like, do y'all know this is a major win, right? This is a major win. Okay, so boom, the Consumer Credit Fairness Act, that's what the new law is going to be called. The Consumer Credit Fairness Act was signed into law last November, goes into effect next month, which is April, and reduces the statute of limitation for consumer debt collection from 6 years to 3 years. Let me see some fire in the chat. New York, It's not 6 years anymore. It is 3. The statute of limitation for collecting on certain credit card debts and certain debts, according to what the Attorney General is saying, is 3 years. It is not 6 anymore. This is a major win for consumers. Let me take a sip to this. Golly. I hope y'all on Clubhouse are taking a sip. This is a major win. Like, this is huge. We're talking about the statute of limitation moving from 6 years to 3 years, people. Bruh. All right, let's keep going. The Consumer Credit Fairness Act of 2021 was signed into law last November, goes in effect next month, and reduces the statute of limitation for consumer debt collection from 6 years. And the word here used is consumer debt collection. So right here, it didn't specify if it was only to credit card. It didn't specify if it was only to personal loans, to auto loans. It didn't specify. Guess what it says? Consumer debt collection. What that means is any consumer debt from 6 years to 3 years. For too long, debt collectors use unfair and abusive tactics to improperly collect debt, which is true. That's why I always keep telling y'all, write to the Attorney General. We are in April. Are we in April? Yes, we are in April. So guess what? New law, new rule, in effect, April. Let's go. Right? So I thought we were still in March for some reason. For too long, debt collectors use unfair and abusive tactics to improperly collect debts, said Attorney General James. Abusive debt collection practices of the past hurt low and moderate income New Yorkers. That is absolutely true. The most and burden of them deeper into financial struggles, which is true, because when these debt collectors are attempting to collect debt from 5 years and 9 months and 340 days, knowing that the statute of limitation ends in 20 days, and they use their methods and they get you back into the statute of limitation by making that payment, it brings low and moderate income New Yorkers more into debt. So I guess the Attorney General has been listening. Ooh, Shay, I got some fire for you. Come up here, girl. I got some fire for you. For your clients in New York, a lot of stuff has changed. So, like I said, just to recap real quick, New York State Attorney General, right? Lilita James, send a letter out to these agencies, these collection agencies, banks, and credit card companies, and letting them know that the Consumer Credit Fairness Act, which is a new law to stop debt collectors, is signed into law. It got signed in last November, and it's effective now in April. And it basically reduces the statute of limitation from 6 years to collect on an alleged debt to 3 years. This is a major, major, major win. All right? And what she's saying is, for too long, debt collectors use unfair and abusive tactics to improperly collect debts, said Attorney General James. Abusive debt collection practices of the past hurt low and moderate income New Yorkers the most and burden them deeper into financial struggles. According to James, who added, I urge any New Yorker who feels that they have been a victim of improper debt collection to contact my office. Run me my coins. Okay. I'm going to take a sip for this. Listen. To everyone listening and watching this right now, if you are in the state of New York, go to New York State Attorney General's website, Find the address. If you believe the Attorney General said this out of her mouth, I urge any New Yorker who feels that they have been a victim of improper debt collection to contact my office. The Attorney General just gave y'all free reign to write and contact her office if you believe that you have been a victim of improper, abusive, unfair debt collection practices. I'm going to say this again. The Attorney General of New York, if you're in New York, said if you are a victim of unfair, abusive, and improper tactics by debt collectors, you need to get in contact with her. Yes, so far this is only for New York. I guess New York is the one kicking it off. So like I said, y'all need to write your attorney generals and let them know that they need to get up and going and start following what New York Attorney General is doing. Because there's so many people suffering from debt collection, unfair debt collection practices act, and the attorney generals need to step in. So yo, people in New York, this is a major win. Yo, let me see that Statue of Liberty. Let me see that Statue of Liberty in the chat for New York. Let me see the Statue of Liberty and some fire if you're in New York. Right? Consumers have the rights, and my office is committed to protect. Listen to this statement, people. Consumers have rights, and my office is committed to protecting them. Can we get some fire for the Attorney General one more time? This is who we need to be running the CFPB. We need New York Attorney General to be running the CFPB, because I don't know what type of leadership they have at the CFPB, but I don't know, man. CFPB, y'all are weak. I don't know what's going on, but I don't know. But we need somebody like this New York State Attorney General, Delita James, to get in office. Like, yeah. Whoo! This is am I the only one here that's happy? Like, do y'all really comprehend? Do y'all really comprehend how much this is going to help consumers? More deletions, more money in your pocket when you find these violations and you're taking them to court. Do y'all comprehend, ladies and gentlemen, what just happened? Yo, all this, y'all need to be writing y'all people in Congress and everywhere, because they need to be following New York example. As of April 7th, listen to this now. As of April 7th, 2022, creditors cannot sue or make a threat to sue consumers over debts that are older than 3 years. Yo! People! New Yorkers! Shay, if you got clients in New York, Chris was here earlier. Where did he go? Do y'all just heard what came out of my mouth from the website that the Attorney General wrote this on? Like, do y'all catch what just happened?
I saw this earlier and I thought it was so good.
Bruh. Can you imagine how much people are going to have improved consumer reports? Listen, as of April 7, 2022, creditors cannot sue or make a threat to sue. They can't sue. They can't make a threat to sue consumers over debts that are older than 3 years. Down from 6 years in most cases. Moreover, any payment a consumer makes after that 3-year period cannot be used to revive the time. Let's go. They cannot reset the statute of limitations either. God damn. This is the most fiery shit I've read all day. Even if that's a word. Listen, do not judge me on that sentence. But this is some fire stuff. I need to see Statue of Liberties in the chat. I need to be seeing fires in the chat. I need to be seeing comments in the chat. Listen, if you're from New York, y'all should be writing this Attorney General telling her thank you. Y'all should be telling this queen thank you. Golly. Listen, as of April, this is the third time I'm reading. It is so good. I gotta read it 3 times. As of 7 April 2022, creditors cannot sue or make a threat to sue consumers over debts that are older than 3 years, down from 6 years in most cases. Moreover, any payment a consumer makes after that 3-year period cannot be used to revive the time-barred debt. What that means, ladies and gentlemen, it cannot be used to redo the statute of limitation. It doesn't reset and start over the statute of limitations. Now, I'm not going to sit on here and tell y'all that, the rain is the greatest thing since sliced bread. But if y'all credit people are not in these rooms, your leaders are not in these rooms learning this stuff so they can give you correct, updated information, I'm just saying y'all need to maybe, ping them into the room. Ping them into the room, because not everybody reads laws every day and is just going to sit down for hours reading. Ping them into the room. If you know credit professionals, if you know people right now that's working hard to build, to repair, to restore your credit, if you've hired someone to do your credit and they are not on this live, they're not on YouTube, they're not on Clubhouse right now, you need to share this live. Everyone, please share this live with 10 people. If you know people in the credit game, share this with them. They need to know this information. Especially if you're in New York and they have clients in New York. They need to know this. The game has changed. So those collections that's on the report, those no, Sway, no. These can't stay on there anymore. These gotta go. These gotta go. These items got to go. All right, let's keep it moving because y'all get me excited. The Attorney General noted that consumers are cautioned that if they make a payment on a debt that is too old for a lawsuit before April 7th, the payment may renew the creditor's ability to sue them for the full amount of the old debt. So now, if you pay prior to April 7th, the statute of limitation is still in effect. After April 7th, it is not in effect. So be mindful. Do not pay. If you're in New York, do not misunderstand what I'm saying. If you're in New York, I can only speak for New York because that's what my Attorney General is saying right now. I don't know what the other states are doing. And as soon as they publish the Consumer Credit Fairness Act, I'm going to read it because I need to know everything that this law is talking about. So, yeah, this is, wow. The entire text of the law can be found here. Okay, boom, let's get it. New York State Senate. Download bill text PDF. Boom, boom, boom. All right, let me download this. Let's see what this new law is talking about. Hold up, what are you? Can't reach this page. Why not? Give me 1 second, ladies and gentlemen. Oh no, this page isn't loading. All right. Let's go over to here then. All right. So Governor, I can't even pronounce his name, Huckle signs Consumer Credit Fairness Act into law. So like I said, ladies and gentlemen, this is a new law. It's called the Consumer Credit Fairness Act. This is a new law that has just been signed into law, right? New law that has been signed into, I know it's weird, I'm repeating myself. Consumer Credit Fairness Act. The reason why I'm saying it so much time, I need it to be burned into the back of y'all minds. I need this to be burned into the back of y'all minds that there is a new law that has just been signed and it's here to protect us. All right? So from the press release now, let's talk about this new law. So we spoke about New York. So let's talk a little bit about the new law and what they're saying. Governor Kathy Hochul yesterday evening signed the Consumer Credit Fairness Act, right? To protect vulnerable New Yorkers from predatory and unscrupulous debt collection practices. The legislation was sponsored by Senator Kevin Thomas, Democrat, who chairs the Senate Committee on Consumer Protection, and Assembly Member Haleen Weinstein in Brooklyn. The Consumer Credit Fairness Act, CCFA, strengthens consumer protections in debt collection proceedings by, bullet 1, requiring a notice to be mailed to the defendants in consumer credit transactions by the clerk of the court, ensuring that defendants are given notice of lawsuit. So if there is a lawsuit, you shouldn't be getting anything from an attorney. You shouldn't be getting anything from a debt collector. What this is saying is the law requires the clerk of the court. So whatever court they're going to file this lawsuit in, the clerk of the court must be the one to send out that mail to notify the consumer. Requiring court filings to include more information about the debt targeted in a lawsuit, such as identifying the debt or account and providing proof that the debt is owed to the plaintiff. So they must now provide more information, provide proof that guess what? They are even allowed to collect on this alleged debt. So that's a huge thing, right? Lowering the statute of limitation for consumer credit transaction from 6 years to 3 years, compelling creditors to file claims in a timely manner and protecting consumers from excessive interest charges and late fees. Establishing specific requirements for applications for default judgment in consumer credit actions to prevent debt buyers from suing unexpired debt. That is absolutely great news. Absolutely great news. So Senator Kevin Thomas said, abusive and exploitative. No, that is wrong, Doreen. Exploitative. There you go. Abusive and exploitative debt collection lawsuits have become an epidemic across New York State. The consequences of these lawsuits, which often prey on the elderly, disabled, and low and moderate income New Yorkers, are devastating, especially at a time when New Yorkers are already suffering financial difficulties as a result of COVID-19. The Consumer Credit Fairness Act will stop these abusive and often illegal debt collection practices in their tracks. I want to thank Assemblymember Weinstein and our hardworking consumer advocates for their partnership and Governor Hochul for standing up for New York consumers by signing the CCFA into law. Congratulations, ladies and gentlemen. That is amazing, amazing news. And for those of you who don't really comprehend yet what this means, it means there's going to be a lot of changes as it relates to your consumer report. Does that mean all accounts are just collections? Well, this is for collections. When I get a full reading of the law, I can give y'all more information. I haven't read that law yet. I'm still waiting to get my hands on it so I can take a few days and really dive into its wonderful contents so I can give y'all back great information. But as it stands right now, this is what is going on, ladies and gentlemen. This is what is going on. New York State has stepped up to the plate. And I want to say, yo, New York, you're doing great. New York, you're doing great. I'm going to say this one more time. New York, you are doing great. Sheeta 3. Chris, where y'all been, man? Where have y'all been? Because I'm talking about some spicy stuff about debt collection in New York, and I'm not seeing y'all. Like, where did y'all go? Because some spicy stuff is happening, man. And y'all need to be on top of this and making sure that our clients are being fed great information that the statute of limitation has changed in New York from 6 years to 3 years. This is great news. And they can't restart the statute of limitations. Well, they have 6 more days. Because the reset of the statute of limitations start April 7th. They still have a couple more days to trick people. But people, if you're on this call, guess what? You know. Well, if you're in New York, I can't speak for the other states yet. So, yeah, let's see if the CCFA, the Consumer Credit Fairness Act, if it's for just New York or is it going to be federal law? Mississippi has always been 3 years. That's good, Shelly. That's really good. All right. So now let's go down here. Assembly member Haleen Weinstein said this. So let's hear what the people that really put this law into place, that got it going, have to say. My legislation will protect consumers from unfair credit card collection practices by debt collectors. Too many improper judgments have been obtained against unsuspecting consumers who have done nothing wrong. Absolutely true. And is the time to add teeth to the law. Whoo! Y'all heard that? She's adding teeth to the law. This is great stuff. Like, this is how much fun I have, ladies and gentlemen, when I'm sitting at home just reading laws. Like, I don't know why y'all are not doing this, but this is the most fascinating thing. I'm telling y'all, I'll just be sitting, taking a sip, reading these laws and just cracking up. Like, bruh. So she's saying that it's time to put teeth to the law to prevent these kinds of debt collection abuses from occurring. I thank the governor and Senator Thomas and all the consumer advocates who stayed the course through the years for partnering with me in getting these much needed reforms to our laws enacted. Oh, Doreen, I sent one letter. Your letters don't work. You only sent one letter. Like, it's not magic. It's not Houdini. Stick with the process. Oh, the rain came back verified. Your letters don't work. How many times did you send it out? Oh, just send it out once. Who did you send it to? I sent it to the credit bureaus. There is no credit bureau. You sent it to the wrong person. Send the letter to the creditor. The stuff works. There's mad receipts anywhere. Everywhere. But if you only send it out one time, beloved, you think magic's gonna happen? And that consumer report that you've been wrecking for 5, 6, 10 years is just gonna get fixed overnight with one letter? No, it doesn't work like that. No, it does not work like that. It took you a period of time to wreck the thing. It's gonna take time to fix it. All right. Carolyn Coffey, Director of Litigation for Economic Justice Mobilization for Justice, a member of the New Yorkers for Responsible Lending, said this. The Consumer Credit Fairness Act levels the playing field for thousands of New Yorkers sued in debt collection cases who cannot afford an attorney, including consumers of color. This is so accurate. Who are disproportionately targeted. Very true. For debt collection. This is so true. We applaud the legislature and Governor Huckle, I hope I'm pronouncing it right, for enacting this important legislation, which closes the gap in existing laws that allow bad actors to benefit from abusive practices, and will help consumers facing the devastating financial consequences of the COVID-19 crisis. Listen, COVID happened in 2020, ladies and gentlemen. We're in 2022. Next year is 2023. That's 3 years. Debts from 2020 expire 2023. This new law is in effect, right? As of April 7th. 3 years statute of limitation. 3. So if you haven't paid the stuff, 3 years, ladies and gentlemen. Now, this isn't any way, shape, or form there ain't telling you not to pay what your obligation is. If it's your obligation, do what you need to do that is in your best interest. But just know, if hypothetically you got some shit in 2020 and you didn't make any payments, well, it's 3 years for them to try to collect on it. After 2023, yeah, you have no legal right to collect on this debt. So, with that being said, ladies and gentlemen, I don't know why all of y'all are not enrolled into my consumer law university. Like, what's up? This is all the sauce. This is the type of stuff you learn in the university. This is the type of stuff you're getting. You are getting information. All right. Think of how many persons you know. YouTube, there's 77 of you. IG, 66. Clubhouse, 41. Think about everybody that is not in this room right now that don't know the information that you now know. Think about the amount of lives you can change. Think about your own credit. How you can fix, how you can repair, how you can restore your own credit. Think about the things you're able to do with this information. You showed up. See, New York only. This is a law for New York, right, ladies and gentlemen? But I don't know specifically yet, because I'm going to do some more digging on this, if the CCFA is a law unique to only New York, or if they're going to go to the federal level with it. As it stands right now, this is New York. This is a law for New Yorkers, right? This needs to go federal. And for it to go federal, the Congress needs to be involved. So the Congress is not involved yet because based on what I am reading here, this was passed using the governor of New York and the attorney general and some other members of the Senate team for New York. So this is a law right now for New York. I would imagine the next step for this to go is the federal level, where they will take this to Congress for the Congress to put this into federal law. I'm telling you, that would be a game changer. Once this hits federal, this is a game changer. But for right now, this is unique to New York. So y'all need to be writing your attorney generals, ladies and gentlemen, to have them follow what the state of New York is doing. because the state of New York just stepped up tremendously and they have given so much power back to the consumers. All right, so, whew. All right, now that we've spoken about that, boom, 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 let's move on to the next thing on my calendar. All right, debt collectors. So there's a website, right, where you are able to check per state the requirements needed for a debt collector to collect items in your state. So if you go to Google and you type in debt collection licensing statutes, debt collection licensing statutes. I swear I just saw my guy Jeremy. What's going on, King? Shout out to my guy Jeremy. What's good? What's good? What's good? Debt collection licensing statutes, right? Now it's gonna bring you up to a page where it's gonna say navigating state debt collection licensing. So basically what this website does, so if you're getting correspondences from debt collector and you want to know what the requirements are for your state, this is the website that you come to. And when you come to this website, it's going to tell you all the requirements that a debt collector needs to operate in that state. So for example, let me find New York. Where is New York? Because I'm an island boy. Boom, boom, boom. All right. So New York. State of New York. Debt collectors don't need a license. They don't need a bond. Possible exemption, none. Resident manager, collector registration, background check. So nothing. New York is, and this is why. So this is also one of the reasons why this law, the Consumer Credit Fairness Act, was signed into law, is because there's no real regulation for debt collectors in New York. Because I'm looking at the debt collection licensing statutes, and for New York right now it's saying that debt collectors don't need a license, they don't need a bond, exemptions no, resident manager, they basically nothing. They can just come here and set up shop. So let's see what Pennsylvania. So for debt collectors operating in the state of Pennsylvania, they need a license. The bond amount is $5,000. Possible exemptions, yes. Resident manager, no. All right, boom. And they have to go through a background check. New Jersey, they need a license, a 5K bond. No. All right, let me go to North Carolina. For the state of North Carolina, a debt collector needs to be licensed. They need a bond amount of $10,000 to $30,000. There's some exemptions. Resident manager, collector registration. They don't have to do a collector registration, and a background check. All right, let me move to Florida. For Florida, they need a license. Bond amount is about $50,000. Possible exemptions, yes. Resident manager, no. They don't have to register as a collector. So this is a very, very handy tool. Alabama, they need to be licensed, but there's no real bond amount. And let me see, Texas, like it has all the states. I'm not gonna go through all the states, but when you pull it up, so if you put into Google debt collection licensing statutes, it's going to bring you to, or if you go to cornerstonesupport.com. So www.corner, cornerstonesupport.com, and it's going to bring you to the debt collection navigation website. And basically when you hover your mouse around it, it's going to give you the requirements for debt collectors in that particular state. That's right, get them, bro. Of course, bro. listen, this is one of the other things where my boy Jeremy, when we have the information, we give the information, right? We give the information. If your person, right, if you cannot give your best away for free, you don't know enough. All right, Myron Golden told me that. And I'm not saying, ladies and gentlemen, that you're just going to be giving away your courses, your content, and everything for free. No, that's not what I'm saying. But if you're here to help, provide enough information where someone can do for self. Like, if someone's going to spend money with you, they're going to spend it. Like, all of this that I'm giving away for free, I'm recording this. And I'm going to make sure that everybody in my university has this. So when this goes away over here on YouTube and Instagram, this will forever be in my university. Just like all the other stuff that I got going on. The child support guide. I can't tell y'all, I got some stuff coming. I got some stuff coming. I can't tell you guys yet. I got some stuff coming, all right? Oh, by the way, ladies and gentlemen. Oh, a bear is here. So let me get her on stage. I have phenomenal news. I've received over 2,000 emails regarding one thing. And on the classes, on the challenges, on the Zooms, on the lives, and it got fixed yesterday. Yesterday, ladies and gentlemen, I got approved for financing for the university. We got financing, y'all. We got financing for everyone that wanted financing, for everyone, all you 2,000 and change people who have emailed me about financing. Your boy got financing. We have financing. We got financing, ladies and gentlemen. Do y'all know how long I've been battling to get this financing stuff? It is here. It is here, ladies and gentlemen. We have financing. And for those of you who want financing, it is available. God damn it. Let me see some fire in the chat for your favorite credit hero. Right? So right now, can I pin two things? Am I able to pin, add as a moderator? Okay. Boom, Nish is a moderator. What does that mean? Nish, see if you're able to pin your own comment. Because I pinned one, but I don't know if you can pin one. So I add you as a moderator on Instagram. I don't know what the capabilities are. But we got financing, ladies and gentlemen. We got financing. We got financing. We got financing. Like, this is big news. This is huge news. So, right now, for those of you who are interested in financing, listen, follow me right now. Follow me. Text finance. Text the word finance to 74121 to receive access to apply for financing. Excuse me, I'm going to say this again. Text finance to 74121 to receive access to apply for financing that you can now. Yes, even with bad credit, they approve as low as a person with a 500 credit score. I could have sworn I saw Marsha somewhere. Boom, boom, boom. Okay. Yeah, so they go as low as 500 up to, I believe it's like 800 or whatever. But they do finance. And so, yeah, ladies and gentlemen, we now have financing for the university. That is a major, major win. We have financing. If you text the word finance to 74121, you will receive the link and you go apply and you come join the university, and let's take these debt collectors out of business. Let's go. Yeah, I got mad fire in the chat. Let me see some money in the chat, because no, y'all got money. Let me see some money in the chat. Let me see some money in the chat. Let me see some moolah, some guac, whatever y'all call it. Let me see some moolah in the chat, ladies and gentlemen. So now, all right, we covered 2 things of the 4 things so far, all right? We covered 2 things. So we covered the new law, the CCFA, the Consumer Credit and Fairness Act. That's the new law that's applicable to New York right now. It is a New York law where, just to recap, so for people that just came in the room, I'm going to do a quick mini recap. New York Attorney General, shout out to this queen right here, Lilita James, they signed into law the CCFA, which is the Consumer Credit Fairness Act. And for New Yorkers, what that means is, y'all know New York had a 6-year statute of limitation to collect a debt. Well, not anymore. It's now 3 years. So that 6-year statute of limitation has been cut in half. So it's 3 years for any collector or creditor to attempt to collect on any defaulted debt. All right, so now debt collectors, they can't sue you or threaten to sue you anymore on any account. You know what? Let me not say the wrong thing. Let me get it straight back from the horse's mouth. This is just a quick recap, everyone, before I go over to the other before I go over to medical collection. New York Attorney General Lilita James recently sent letters to the largest credit card companies and major debt collection operating in New York, warning them of the new state regulations that prevent them from suing consumers for old debt. A new law protecting debtors goes into effect in April 7th to be exact. The Consumer Credit Fairness Act of 2021 was signed into law last November, goes into effect next month, which is this month because this was written in March, and reduces the statute of limitations for consumer debt collection from 6 years to 3 years. For too long, debt collectors used unfair and abusive tactics to improperly collect debt, said Attorney General James. Abusive debt collection practices as a part of the past hurt low and moderate income New Yorkers the most, burdened them deeper into financial struggles, according to James, who added, I urge any New Yorker who feels that they have been a victim of improper debt collection to contact my office. So if you've been a victim, y'all need to be hitting up my Attorney General. As of April 7, 2022, creditors cannot sue. Listen to me. As of April 7, 2022, creditors cannot sue or make a threat to sue. They can't sue or they can't make threats to sue over debts that are older than 3 years old. If the debt is over 3 years, they can sue. Where you been, man? We haven't seen you in a grip. You disappointed on the IG family. Bro, I gotta study. See, when you don't see me, I am studying, I am researching, I'm reading. If I'm on here every day, it takes away from my study time. And in order for me to be bringing y'all information that is relevant, information that is needed, sometimes I gotta go away for a few days. And this is only for New York as of right now. So when you see me disappear, just know, and I want all of you to know this, When you don't hear from me in a day or 2 or 3, just know that I am working on something. I am working on something. All right? And this right here, this for people in New York, for credit repair owners, for credit repair business owners that have clients in New York. As of April 7th, this is a game changer. So you are going to need new letters. You are going to need new letters. I will be building some new, I'm going to build some new letters. These letters are going to be called CCPA. And these letters will, if you're not in New York, do not use these letters. They probably won't work if you're not in New York. So on the website, I will make a notation that this is CCPA letters, which is the Consumer Credit and Fairness Act letters for New Yorkers. So if you're not in New York, do not buy these letters and send them out and then tell me that the letters don't work. They don't work because you probably are in a different state. All right. So I'll be building some new debt collection letters for the CCFA. I do apologize. I said CCPA for the Consumer Credit Fairness Act. So I will be making some new letters so that my people in New York and my credit repair business owners that have clients in New York, you are able to use these letters now for your disputes. All right. So basically, ladies and gentlemen, that's what happened. New York stepped up to the plate. And just before I go into medical collection, I'm going to read the last paragraph. The Attorney General noted that consumers are cautioned that if they make a payment on a debt that is too old for a lawsuit before April 7, the payment may renew the creditor's ability to sue. So do not be making no payments. Wait, if you're in New York. If you're in New York and debt, listen to me. If you're in New York and debt collectors are hounding you, do not make no payment. Wait until April 7th. And then we're going to have a new conversation. All right? 3 years is the statute of limitation. 3 years. April 7th, the Consumer Credit Fairness Act goes in. It's live. It is live. Do not pay on debts that are over 3 years. Past the 3 years, do not pay. This is what the law is saying. And they say that if you pay and it resets the statute of limitation, then that's on you. Right? All right. So now, the other thing on the list, which is the third thing, was medical collection. I'm going to do the executive summary from the CFPB because the document is 54 pages and there's absolutely no way I'm going to get through all 54 pages right now. So I'm going to do the executive summary and then we're going to break down what's going to change for medical collection. And then now on ending, we will go to the CFPB website, and then we're gonna touch on Regulation F, which there's new rules to Regulation F under the FDCPA. There's the new rule that took in effect November 30th, and there's a lot of changes to debt collection. So my people, we get taken advantage of a lot. And it's because of the things we don't know that we don't know. But no steps on how to get rid of older altogether unless it's there now. Chris finally came on stage. Finally. All right. Before I go into medical collection, because sometimes I get so carried away and I don't have everybody speak, and I do apologize. I'm going to definitely go around the room right now. I want my moderators to introduce themselves, tell us who they are, what they do, how they can be of service, And yeah, I just be going off sometimes, and I don't take the time. I don't take the time for us to get stuff done. So yeah, let's go around the room right now and have the moderators introduce themselves. So Queen Nish, are you here? Initially going once, initially going twice. Sheeta 3, are you with us, Sheeta?
I'm here.
Another day, another live. Tell the people about you, Sheeta 3.
What's up, Double D?
What's going on, Sheeta 3?
I can always count on the rain to have the new laws interpreted, and ready to go.
You sound a little low.
Listen.
I want my people to be able to hear you on Instagram and on YouTube.
You can hear me?
Yeah. Go ahead.
Alright, cool. So, hello everybody. My name is Rashida, also known as Sheeta 3 on IG. And I teach people how to leverage good credit to travel for free, to enjoy life for free, run plays, and have fun. So Durain is all about helping you get your empowerment by learning how to repair, restore, and rebuild your credit on your own. And once you get that empowerment, I pretty much teach you how to build it up and have fun with it. All right? I don't believe anybody should travel in the back of the plane. I believe first class is for everybody and not just those who think they got to pay cash for it. I don't ever think you should sit back there, and I want you to enjoy the luxury of life for free. So, that's me.
I like that. And ladies and gentlemen, Sheeta 3, I'm waiting for her to finish her course. Sheeta 3 will be teaching this in the university. So her course is going to be in the university when she finishes it, and you will be able to tap in to Sheeta 3, join her network, be great, and live y'all best life for free. All right, so we're working on putting a lot of stuff in the university. Sheeta 3 definitely has a spot in the university where she will be teaching you all the hacks of life and basically how to live free off your credit cards. So yeah, shout out to Sheeta 3. Marsha, talk to me. Sheeta, you said something?
I said, let's go.
Let's get it. Let's go. Marsha,
Hey everybody.
what's going on? Oh, everybody low. Where?
I just came in to say hi and show some support.
All right.
Niche, Chris, hey, how y'all doing?
Good.
With the family now, it's loud, so I just wanted to say hi to everybody.
I bet.
All right.
Appreciate you, Queen. Thanks for always showing up.
Yeah, I figured you was working on something. I'm text you like, where you been?
Yeah, reading up, getting spun up on these new laws. Getting spun up on these new laws.
Yes, I see you.
Mm-hmm. All right. Chris, what's going on, King? Can you speak?
Durain, what's going on,
You tell me, King, what's going
I'm
on?
gonna give you a call one of these days.
Huh?
And it's been a minute.
Yeah, we got a lot of catching up to do.
Your clubhouse Friday nights. How
We're-
lit they are.
We're getting them back up and going. Is that we had a lot of stuff doing, and it's just a lot. But now we're getting everything back on in line. We have financing for the university. It was one of the biggest things that was holding a lot of students back that wanted to join, that wanted to be great, that wanted to learn. Having been able to finance their way into the university, now we have financing. It's going to be great. Everybody can now join. Well, not everybody, because the university is not for everyone. Everyone, well, not every, why do I keep saying everyone? Everyone that is qualified to join the Consumer Law Secrets University, we now have financing. It's going to be great. It's going to be amazing. King, tell the people who you are, what you do, and how you can be of service.
my name's Chris. Credit restoration is pretty much what I do. And I help people build their credit up after we're done repairing it. And pretty much any other service, I'll send you guys to Durain or Sheeta, because they're going to teach you what to do with those cards, how to leverage your credit, and go beyond that. So this is the fam right here. This is the squad.
Day one. These are some of my day one people, y'all. Day one. Miami recession proof. My day ones. All right, bet. So now let's go over to medical collection. So a lot of you know that there's going to be changes with medical collections as it relates to your consumer reports. So I have an article right here. Well, y'all on YouTube and IG can't see it. Clubhouse, y'all surely can't see it. But the the Zoom, and I hope Abir is streaming this to Facebook, y'all can see my screen. And basically, this document came directly from the CFPB, Consumer Financial Protection Bureau, dated February 2022. So this is a document that was just published last month. Let me see some. In Illinois, the 7th Circuit Court is throwing out violations of the FCPA. I don't know what that is. Fair Credit Protection. FCPA. No, bro. Fair Credit Protection Act. And FDCPA. That is without standing. In other words, if a medical debt collector violates the FCRA and the FDCPA.
Foreign Corrupt Practices Act.
FCPA? Alright, seems like I need to get...
That's what it looks like.
Yeah, it seems like I need to research that law and get familiar with it. I've never seen the FCPA before. Interesting. Alright, cool. So, Chris, write that down. I'm gonna tackle that later. I want to see what that's about.
Gotcha.
Alright, so let's do an overview now. Boom, boom, boom. Let's get into the executive summary, right? So, key findings of this report. CFPB research shows 88 billion in medical debt on consumers' credit records as of June 2021. The total amount of medical debt in collection in the US is likely higher, since not all medical debts in collection are furnished to consumer reporting companies. Most medical debt collection trade lines on consumer credit reports are under $500. Although many people with medical debt have multiple medical collection trade lines. As of 2021, 58% of all third-party debt collector trade lines were for medical debt, making medical debt the most common debt collection trade line on credit records. The next most common collections trade line was telecommunication debt at only 15% of trade line. Past due medical debt reported to consumer reporting companies can appear on a person's credit reports and lower their credit scores. This may reduce their access to credit and make it harder to find a home or a job. Medical debt collection are less predictive of future payment problems than other debt collections are. Certain newer credit models take into account, but some widely used models still weigh medical and non-medical collections equally. Black and Hispanic people and young adults and low-income individuals of all races and ethnicities are more likely to have medical debt than the national average. As a result, these populations may be more heavily impacted by outdated credit models that overestimate the predictiveness of medical debt. Older adults and veterans are also heavily impacted by medical debt. Additionally, medical debt is more prevalent in the southeastern and southwestern U.S. Medical bill amounts can be unpredictable and often vary widely based on patient and provider characteristics. Uninsured and out-of-network patients are often charged prices that are much higher than what in-network insurers pay. Even though the unsecured may have little ability to pay, the prices are charged to uninsured and out-of-network patients sometimes significantly exceed providers' costs. Markups are especially high for emergency care and for-profit investors. And for-profit investors, owned hospital charge higher average markups. So, the other part, boom, boom, boom. Where is it? Not that. That's child support. So, ladies and gentlemen, medical collection. See, medical, CTI and CFPB. Medical collection is really a nuisance to a lot of people. And they didn't just figure this out yesterday. They didn't. They didn't just figure this out yesterday. They've been known this. But it took a situation where, let me see. We just got through that. We just got through that. All right. So right now I'm on NCLC, which is the National Consumer Law Center. And I have a publication here from them that I'm going to go over. And then I'll take some questions, and then I'll close out with the FDCPA new rule that took in effect November 30th. Medical debt collection. All right. The CFPB should protect consumers, right? The CFPB should protect consumers with medical debt from abusive debt collection practices. If y'all believe that is true, let me see some fire in the chat. The CFPB should protect consumers with medical debt from abusive debt collection practices act. If y'all believe that is true, let me see some fire in the chat. All right, guess nobody believes that's true, so I don't see any fire in the chat. All right. So if the CFPB ain't going to protect y'all, who you think is going to protect y'all? If they're not going to do it, you better do it. So why Darain comes on here every Friday during multiple days during the week. Okay, I see the fire's coming in. And speak about these consumer law stuff because you need to know them. You need to know them, beloved. You need to know them. You need to know them. If you are not able to protect yourself, and these corporations that exist to protect your rights are not doing it, what do you think is going to happen? I really want y'all to think about it, right? They are put in place. They are given certain power to protect the consumer. But there's so many consumers. What do you think you need to do? On the bigger scope of things, you're just a number. But who protects you? Who protects your household? Who protects your family? Who protects your consumer report? If you are going to wait on the CFPB and the government to come save you, what about you saving yourself? Can we do that? Like, can we say enough is enough? Maxine, you took the words right out of my mouth. Enough is enough. Like, when am I going to stand on my own 2 feet? Or am I going to let my freedom, my rights, my liberty, put it in the hands of somebody else? Like, when do we say do for self? Like, when do I say, all right, I'm going to stop blaming the rain. I'm going to stop blaming Sheeta. I'm going to stop blaming Chris. I am going to make a change. And the change is I am first going to accept responsibility that it is my credit report. It is my consumer report. When are we going to say I am going to be responsible for my own action? I'm saving up for your course. I stopped watching everybody else. Mac Miller, I have financing. I got approved for financing. So if you text Mac Miller, text the word financing. Text financing to 74121 and you will be able to get my link to get finance for you to join the university. So I got finance and it is dope. All right. So text the word finance, or what is it? Finance. Let me go find it back. I think it's finance. Should be finance. But I believe it's financing. So if you text financing to 74121, it will bring you the link that you're able to apply for financing and you're able to join the university. Man, where is that link? Boom, boom, boom. Yeah, so it's finance. Text the word finance, FINANCE. Text the word finance to 74121. I'm going to say that again. Text the word, not financing, I'm sorry, Wild079. It's not financing, it's finance. Text the word finance to 74121 if you want financing, if you want to join the university. Text the word finance to 74121. Now, let's go into some of the reasons or some of the ways that the CFPB should be, will we get financing if we are in early warnings or check systems. My lender didn't specify, but it's a soft pull. So you're going to do a pre-qualification. The pre-qualification is a soft pull. So if you don't get accepted for financing, then it's like it never happened. But if you do get accepted and you do meet all the requirements, then no, it will be a hard pull and you'll have an inquiry. But guess what? You will learn how to delete the inquiry anyway. So, hello. Next year they're going to be hitting your finance company with your letters. Requiring collectors and healthcare providers to wait 180 days after issuing a bill before reporting a debt to a credit reporting agency. So what NCLC is saying on this document is basically the CFPB should protect consumers with medical debt from abusive debt collection practices by doing these things. And the first bullet is requiring collectors and healthcare providers to wait 180 days after issuing a bill before reporting a debt to a credit reporting agency. The second bullet is preventing unpaid medical bills from harming patients' credit reports and scores if the unpaid bills are due to billing errors or insurance disputes. That is great. That is a great point. Requiring collectors to provide a warning notice before placing negative information about a medical bill on a consumer's patient report. Well, with the new FDCPA rule, they can't just put no collection on your consumer reports anymore. So the new FDCPA rule, right, regulation F, speaks on the no parking rule, where a debt collector cannot put or park any collection on a consumer's credit report without getting in contact with the consumer to whom this alleged debt is. Shout out to Miss Haiti, to who this debt collector is trying to collect from. So let me bring it right back. There's a rule, this law, right? The new FDCPA, which took effect on November 30th, 2021, 2021, says basically this. There is a rule called the no parking rule. Any debt collector, if they do not get in contact with the consumer to whom the alleged debt is related to, they cannot park the debt on the consumer report. They cannot. So whether by mail, by DM, by telegram, phone call, before any debt from a debt collector or a debt buyer gets placed on a consumer report, contact must be made with the consumer to whom it relates. Right? So you can't just get up after November 30th. If there's anyone on here, if there's anyone in YouTube, on Instagram, and in Clubhouse, after November 30th, 2021, if there's a collection account that popped up on your consumer report after November 30, 2021, let me see y'all say me in the chat. I want to see. Because y'all need my letter. Gangster with the info. Thank you. Thank you very much. So let me see if there's anyone on here that a debt collector. Oh, Brian, really? Okay. Okay. Wow. All right. This is crazy. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. This is crazy. Now, this is crazy. This is crazy. And this is where I'm going to lose my shit. Because this is crazy. The new rule. So the Zoom, text the word free. No, not free. Text FDCPA. So the master class that I'm giving away, the FDCPA, I want you right now. This is free. You're not paying for this. Everyone that said me, text the word FDCPA to 74121. You are going to get my Zoom masterclass overview of the new rule. This is completely free. Absolutely free. Learn the stuff. And I would love to see y'all in the university. But this is a consumer violation under the FDCPA of the new rules, and you are owed remedy, ladies and gentlemen. Text the word free. Free, free, free. Text, not free. I keep saying free, goddammit. Text the word FDCPA. Text the word FDCPA to 74121. You will get a link to my free masterclass where I covered the new rules. It's an overview. It wasn't an in-depth dive. It is an overview, but you are going to be, what if it was added before November 30th? Then the new rules don't apply. Xavier? Oh, okay. If it's before November 30th, then the new rules don't apply. The new rules applied after November 30th. Hey there, King. What's up, Credit Queen? So the new rules took effect after November 30th. So for everyone on YouTube, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Bruh. Everybody on YouTube, all 10 of you, and all 15 of you on Instagram that text, that DM'd me, get this free training. Become educated. Become educated, ladies and gentlemen. Text the word FDCPA in all caps to 74121. Get the training. Spend the time. Learn the stuff. If you decide to join my university after, that would be amazing. If you don't, that is still fine. But please, 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 get the information. Get the information. It is a free class. Get the information. Because after November 30th, and they put collections on your consumer report, that is a violation of the law. We have a responsibility. We have a duty to ourselves, to our families. We should not be going into second quarter with bad credit. I just gave y'all three things. If you're in the state of New York, a lot's going to change for you. A lot. April 7th, a lot's going to change if you're in New York. The statute of limitation changes from 6 years to 3 years. A debt collector cannot threaten to sue you. They cannot sue you for debts older than 3 years. If they trick you and you pay on an alleged debt, it doesn't restart the statute of limitations. The FDCPA new rule says that after November 30th, a debt collector, debt buyer, debt servicer cannot illegally park any item on your consumer report without notifying the consumer to whom this alleged debt is related to. When you get their mail, send it right back to them. Send their mail back to them. What to do if I have collections from 20 years ago? Hold on. Wait a minute. Let me take I need a shot for what I just read. Hold up. I need a shot for, I need a shot for this. There's no way. Absolutely no way, Sway. Let me take a shot. Let me just. Whew. I just read some stuff. Hold up. Where did. What to do if I have collections from 20 years ago? How? That's not possible. You are owed so many remedies. No, Sway. There's no way. There's no, bruh. You need to hit up my line. We need to get on a consultation. You need to be in the university. Queen, let me find you. You need to text the word finance to 74121. You need to come into the university. You need to be in there. Because ain't no way, Sway. No. No. 20 years, you need to be in the mentorship. You need to be in there right now like yesterday. You need to be in there. Ain't no way, Sway. Ain't no way. Ain't no. It's not whiskey. It's pure white Hennessy. You're not able to get this, well, in the U.S. There you go. So when I went to Jamaica, because I'm an island boy, I brought up a few bottles with me. All right. So had to jump over from Clubhouse real quick. Maybe she made payments before the statute of limitations and kept renewing it. See, that could be a thing, but this is why now. See, this is why New York stepped up, you know. This is why New York stepped up to the plate, because of situations like this. This type of stuff shouldn't be happening. This queen should not have that on her credit for 20 years. No. Ain't no way, Sway. No. If we cannot tell, is the debt collector notice before we open the mail? If you can tell that it's a debt collector notice before you open the mail, see who it's coming from. Google the name of the company. If there's no name on the envelope and you don't know who it's from, you shouldn't be accepting no mail from nobody you don't know. Because first thing, there is no law that says you have to accept any mail. If someone can find me a law that says you have to accept any mail, come show that law to me, because I haven't seen it yet. All right? That's number one. Any letter, correspondence that come to you in the mail and you don't know who it's coming from, send it, return to sender. If you are not expecting that mail and you don't know who it's coming from, return to sender. Somebody wants to get you into jurisdiction for some shit. Do not do it, beloved. Do not do it. Do not do it. All right? Man, I've been ranting all evening. God damn. Y'all want me to stop? If y'all are ready for me to stop, just let me know so I can stop. If y'all are ready for me to stop, just let me know. Because my voice is getting a little tired. My drink is almost finished. See? Drink is almost finished. So if y'all are ready for me to stop, just let me know. Y'all want me to keep going? If y'all want me to keep going, let me see y'all say keep going. Let me see some fire in the chat. I don't know. Let me see something. Island boy. No, bro, you're good. Like, do y'all really want me to keep going? You need a moment to recoup. Man, that what I just read about that 20-year got me so upset. It just got me so upset. It really got me upset. No one should ever have to go through that type of stuff. No one should ever have to go through that type of stuff. I'm really upset. I'm really upset. Can y'all share this live with some more people, please? If y'all can share this live with like 5 or 10 more people. Clubhouse, if you can ping some more people in the room, that would be great. YouTube, whoo, y'all numbers have gone up. If y'all can still share this live with anyone that you think can benefit from this, that would be so great. Don't forget, ladies and gentlemen, do not forget, I am giving away a free masterclass that I did on the new FDCPA rules, which I'm about to cover. Text the word FDCPA to 74121 and you will receive the link for the FDCPA free masterclass. If you want to join my university, if you want to join the community, if you want to be a part of the Consumer Law Secrets family, if you want to be a part of our community, please text the word finance. Yes, please text the word finance to 74121. Question about finance. Do you know how much the monthly pay? No, and if you get approved, I'm not sure. That's what you're going to have to work out between you and the financial institution. That information I do not know, because different people will apply and get approved for different amounts. How can I get my credit straight by you? You need to join the university. You need to learn how to repair, rebuild, and restore your own credit. Shout out to Memphis, Tennessee. Shout out to Linda. Linda saved me a bottle of Jack. Have my bottle of Jack. I like Jack Honey. You can save my bottle when I come to Tennessee. Not sure when yet. Just put a bottle aside for me, all right? When I'm coming to Tennessee, I'll announce it, all right? And so if you've texted the word FDCPA to 74121, let me see y'all put done in the chat. YouTube, Instagram, and Clubhouse, if you have, just DM me, back channel me. Done. So if you've texted the word FDCPA to 74121 to get the free training, just comment and done. Stay getting gems. Boss Music. What's up, my guy? From your YouTube. Shout out to you, boss. Shout out to you. Yeah, if y'all just type the word, just put the word done in the chat so I can see that I'm not just out here just wasting time, and I could have been selling this course and I'm giving it away for free. Because like I always said, if you can't give away your best for free, you don't know enough. And that's something that Myron Golden told me, and it's been stuck with me ever since Myron Golden said that. So I want you to also text the word FDCPA to 74121. Get the free masterclass. Learn the sauce. You can join the university. There is no pressure. The key thing is I want everybody here empowered so we can start taking our power back, so we can really start doing more things. All right. The next commercial break that I'm going to do before I go into now the new rule on the CFPB website is financing. If you want to join the community, if you want to join, just text the word finance to 74121. 74121. Text the word financing. Not financing. Text the word finance to 74121 and you will be able to get tapped in. All right. Myron Golden, that's my guy. Absolutely. Myron's the GOAT. All right. So the FDCPA is extremely long, but the part that I want to cover tonight is, let's see, I'm going to go through communications, acquisition, harassment, false or deceptive and misleading, unfair, collection of time-barred debts, prohibited practices, notices. I'm going to cover this section, and then, ladies and gentlemen, we're going to call it a night. So if you're ready for the new rule. So for those of you who don't know, November 30th, the new FDCPA rule came in effect, and it came with a lot of changes. You'll hear some people say, oh my God, debt collectors now, they can text me, they can find me on social media, they can do this and do that. Well, if you look at it as being a victim, then you will be a victim. But if you look at it as an opportunity for you to really use consumer laws and really make some money, it's a great opportunity. So, without further ado, ladies and gentlemen, You know what? Let me make myself another drink because I don't want to stop once I start. Let me make another drink and then we're going to get into it. Sheesh. Alrighty. Don't forget, pinkies up, alright? Pinkies up. And now we are going to go into the new rules. Yeah, you're going to get the text very soon. Wild 079. It's going to come through very soon. All right. Y'all ready for this? Let's get it. All right. So, for those of you who want to follow where I'm at, if you Google right now, rules for FDCPA, section 1006.6. If you Google that, it's going to bring you to the CFPB website, and it's going to bring you to 12 CFR part 1006, aka Regulation F, aka FDCPA, aka 15 USC 1692. All right. So type into Google section 1006 and it will bring you here. So we're at 1006.6. All right. For the purpose of this part, the following definitions apply. All right. Boom. All right. We're not going to be doing definitions. We're going to move right into communication. All right. So communication in connection with debt collection, right? Definition. For the purposes of this section, the term consumer includes, number one, the consumer's spouse. Number two, the consumer's parent, if the consumer is a minor, right? And three, the consumer's legal guardian. And number four, the executor or administrator of the consumer's estate if the consumer is deceased. Now, if you remember the old rule, the deceased person was not a part of the definition. In the new rule, they have added the executioner or administrator of a consumer's estate if the consumer to whom the debt is related to is a deceased person. Right? And number five, a conformed successor in interest as defined in Regulation X, 12 CFR 1024.3, 3.1, or Regulation Z, Truth in Lending, or they go more. All right? So, communications with a consumer. So, prohibitions. In paragraph B4 of this section, a debt collector must not communicate or attempt to communicate with a consumer in connection with the Okay, here we go. A debt collector must not communicate or attempt to communicate with a consumer in connection with the collection of any debt. And one says, at any unusual time or at a time that the debt collector knows or should know is inconvenient to the consumer in the absence. So before I go into the second statement. So if you make it known that between 8 a.m. and 9 p.m. is an inconvenient time for you, for a debt collector to communicate with you, and they know this and you send it in writing, and they still attempt to call you, it is a violation of the section. The second sentence says, in the absence of the debt collector's knowledge. So now, if you don't put the debt collectors on notice, if you never sent nothing to the debt collector, so in the absence of knowledge of circumstances to the contrary, a time before 8 a.m. and a time and after 9 p.m. local time at the consumer's location is inconvenient. So let me explain this. They can call you a time before. This is the new rule. This is not the old rule. The old rule said they could assume that they could call between 8 a.m. and 9 p.m. This new rule, remember, old rule, new rule. Old rule said between 8 and 9 they can assume in the absence of information. Here, new rule says in the absence of information, it must be before 8 a.m. or after 9 p.m. local time to your time zone. All right? How do you get paid for their violation? Well, you need to learn what to look for. In order for you to get paid, you need to know what you're looking for. Then you put those together. Then now you go file your lawsuit. Or you could invoice them. So, official interpretation. So let's get to the interpretation of what. Man, this interpretation is long as hell. No. At any unusual place or at a place that the debt collector knows or should know is inconvenient to the consumer. So if you make it clear that it is inconvenient for a debt collector to contact you between certain times or at a specific location, and they still do, it is a violation of the section. All right. Prohibitions regarding consumer represented by an attorney. Except as provided in paragraph before this section, a debt collector must not communicate or attempt to communicate with a consumer in the collection with any collection of any debt. In the debt collector knows the consumer is represented by an attorney with respect to such debt and knows, or can readily discern the attorney's name, address, unless the attorney, right, fails to respond within a reasonable time period to communication from the debt collector. Or number 2 says consents to the debt collector's direct communication with the consumer. So what they're saying is if you're represented by an attorney, a debt collector should not be contacting you. All correspondence should be going to the attorney, unless if they attempt to contact the attorney and there is no response from the attorney, or if the attorney says it's okay for you to contact my client, then they can. Exceptions. The prohibitions in paragraph B1 through 3 of this section do not apply when a debt collector communicates or attempts to communicate with a consumer in connection with the collection of any debt with the prior consent of the consumer given directly to the debt collector during a communication that does not violate paragraphs B1 through 3. So if you had given a debt collector permission to contact you, they're able to without having to go through your attorney. Exceptions. The prohibition in paragraph C1 of the section does not apply when debt collectors communicate or attempts to communicate further with a consumer with respect to such debt. To advise the consumer that the debt collection further efforts are being terminated, to notify the consumer that the debt collector or creditor may invoke specified remedies that the credit debt collector or creditor ordinarily invokes, or where applicable, to notify the consumer that the debt collector or creditor intends to take their specified remedy. So now we're at D. Communications with third party. Prohibitations. Now listen to me. Except as provided. I hope y'all are taking notes. I really hope y'all are taking notes. I know it's a lot of information. And I'm thinking that I shouldn't probably be covering 2 laws in one live. I probably should separate them with and do this next week. That's what I'm thinking, because it's gonna be a lot of information, and I don't want you to have information overload. So let me know right now. Do y'all want me to keep going? Are y'all taking the notes? Or do you want me to save this for next week and we go into this for next week? Let me know. Are you saving this live? Yes. Let me know if y'all want to do this, because it's a lot of information. And I need to know that I'm not going to fry y'all brains, because I need y'all to comprehend the information. So if this is too much, we can break the FDCPA apart and we can go over it in a few weeks. But there's no rushing the right thing. I don't want y'all to think this is a race. This is not a race. This is for you to learn. This is not a race. This is for you to learn and be proficient in handling your own situations. Seriously, yo, Doreen, I just received my STEM player today. Thanks again. You're welcome. You're welcome. You're welcome. You're definitely welcome, King. You're welcome. I appreciate you for coming on the challenge. I appreciate that. So everybody's quiet. I need y'all to talk to me. If not, I'm just gonna stop, because it's a lot of information. It's a lot, and I want to know that you guys are getting the stuff, right? Definitely not a race. It's over life change, not overnight. Absolutely. So with what I just said in the beginning, I think that is, I will watch the live. What's good, man? I want to give y'all an the opportunity to soak the information up. It's a lot of information. All right, I'm seeing keep going, don't stop. All right, cool. All right, so let's get it. Let's get it. Communications with third parties. So let's get it. Number 1, prohibition, except as provided in paragraph D2 of the section. A debt collector must not communicate in connection with the collection of any debt with any person other than the consumer attorney, a consumer reporting agency if otherwise permitted by law. Listen to this. A consumer reporting agency if otherwise permitted by law. Interesting. The creditor, the creditor's attorney, or the debt collector's attorney. And then the exceptions here, the prohibition in paragraph D1 of this section does not apply when a debt collector communicates in connection with the collection of any debt with a person for the purpose of acquiring location information as provided in section 1006.10 with the prior consent given directly to the debt collector, with the express permission of a court of competent jurisdiction as reasonably necessary to effectuate a post-judgment judicial remedy. So number 3 says reasonable procedures for email and text message communication. So remember earlier I said that no, debt collectors, they're able to email you, they can text you and stuff like that. So no, we're going to speak to this section of the law that covers the text and email. A debt collector maintains procedures that are reasonably adapted for purposes of FDCPA Section 813C to avoid a bona fide error in sending an email or text message communication that would result in a violation of paragraph D1 of this section if those procedures include steps to reasonably confirm and document that. Now, number 1 is saying the debt collector communicated with the consumer by sending an email to the email address described in paragraph D4 of this section, or a text message to a telephone number described in paragraph D5 of the section. The debt collector did not communicate with the consumer by sending an email address or text message to a telephone number that the debt collector knows has led to a disclosure of prohibited by paragraph D1 of the section. So that's violated my privacy and permission. Are they able to hire private investigators? Nothing in the law says anything about private investigators. So this is why I said no. It's crucial for you guys to know this stuff, right? It's crucial to know it. Number 4, procedures for email addresses. For purposes of this paragraph, D31 of this section, a debt collector may send an email to an email address. So if a debt collector has your email address, they can send an email to you. The consumer used the email address to communicate with the debt collector about the debt, and the consumer has not since opted out of communication with that email. So if you are in email communication with a debt collector and you don't opt out, then they're able to communicate with you via email. If you opt out of that email communication, then they cannot email you regarding any alleged debt. So let me go back again. If you, the consumer, is communicating with a debt collector via email, a debt collector can correspond with you via email. But if you opt out of that email communication, they cannot still send email correspondence to you. Just cease and desist a debt collector about an alleged debt. Absolutely. Procedures based on communication between the consumer and the debt collector. The consumer used email. Oh, we spoke about that already. All right. Procedures based on communication by the creditor. A creditor obtained the email address from the consumer. The creditor used the email address to communicate with the consumer about the account, and the consumer did not ask the creditor to stop using it. So you have to opt out of these things. So when you give your email addresses to these creditors, when you write and you sign and you do all of these things, you can write a letter to a creditor and opt out of having your information used. It's all about the communications. It's very, very important. Before the debt collector used the email address to communicate with the consumer about the debt, the creditor sent the consumer a written or electronic notice to an address the creditor obtained from the consumer and used to communicate with the consumer about the account that clearly and conspicuously disclosed that the debt has been or will be transferred to the debt collector. So basically now, before a debt gets transferred to a debt collector, before a debt collector can use your email address, there is Regulation F, 15 USC 1692, disclosures and statements that must be done by the creditor that they must send you before they can give your information over to a debt collector. So I really hope y'all paying attention to that part. All right. So number 2 says the email address and the fact that the debt collector might use the email address to communicate with the consumer about the debt, that if others have access to the email address, then it is possible they may see emails, instructions for a reasonable and simple method by which consumer could opt out of such communications. Remember, I told you that you have the right to opt out of having your information reported. You have the right to opt out of having your information sold. But the key thing is you need to exercise that right. They're not going to give it to you. You have to exercise the right. So the fact that you're on this call, the fact that you're here, you know that you have the ability to opt out of having your information reported. Boom, boom, boom. So the new rule, it's extensive. It is long. So what I'm going to do is for the next couple lives, I am going to do there's a lot to cover in this FDCPA. And this is going to take a few hours. So let me ask y'all a question. I can put together a masterclass. We can do a masterclass. This masterclass won't be as much as the other one. I'll probably keep this masterclass at around $297. If you want a masterclass on a full deep dive of the new rules on the FDC, are you reading this from the Bureau? Absolutely. I only take my information straight from the source. If you want us to do a full deep dive, there's no way this the new regulation is going to get covered in a live. We can put together a 3 to 4 hour masterclass, right? And if y'all want a full new FDCPA deep dive, let me see some fire in the chat. Let's talk charge off. Today isn't really about charge off. Tomorrow I'll definitely be going over charge off. And if you go on my YouTube, I've made several videos about charge offs, so you definitely will be able to see. You'll definitely be able to see. Do you have beginner's course? If so, can you refer me to it? Well, it's not really beginner's course, but the university is structured in a way where you go from beginning, learning how to dispute items, personal information, cleaning that up, all the way to exercising certain right and using certain exotic laws. But I want y'all to stay tuned. There is absolutely no way this regulation F can get covered in the live. It's not gonna happen. It's too much. It's too much for it to get covered here. So what I'll do is I'm gonna put a masterclass together. I'm thinking between $297 and $350. Let me know which price is gonna be better, $297 or $350, and we're gonna do a FDCPA masterclass where I'm going to go through all the sections of the new law in regards to debt collection practices, new remedies, and stuff like that. So, yeah, I'm thinking between 350 and probably 297. So let me know if 297 or 350, which one would you rather? And I'll set that up, and then we're gonna do this masterclass. 12 CFR Part 1006 is extensive, and there's absolutely no way we'll be able to finish it on just one live. Have you already touched on what's changed? There's a lot has changed. It's a lot. That's what I'm saying. There's a lot that has changed, and it's through all the sections. So I believe what I'm going to do is create a masterclass, not an overview, but a full masterclass. Of course, the 297. So y'all rather 297 than 350 then, right? Okay. So 297 rather than 350. Okay, that's fine. Yeah. So I'm gonna speak to the team, and I'm going to have the team put together that training, and we will be going through the whole, like, I'm gonna warn y'all from now, this might be a 4 to 5 hour Zoom. Looking at the FDCPA, it's extensive. It is not short, especially with the new rules. So this probably will be a 4 hour, 5 hour max, a 4 to 5 hour Zoom. This probably will be that based on all the information that we're going to cover. So anywhere between 3 to 5 hours. It should take us around 3 to 5 hours to cover all the information here. So it's going to be a 297. It's going to be a 297 course, masterclass. We'll do a 297, and let me ask you another question. Do y'all want it to be in person or virtual? Let me know right now. Do y'all want this to be in person or virtual? Because for everybody that wants to go virtual, we can do a virtual 297, and then we'll probably have like a 450 in person. I don't know. Listen, I don't know yet. We're gonna put it together. But we could definitely make this. Shout out to my guy Flame, man. Why you just gonna come in here like that, Flame, and don't even say nothing to me? And god damn it, Brandon's here. He's been quiet. What's been going on, gentlemen? What's been going on? It's been a while. What's been going on?
Dwayne, what's up, baby?
Man, these new rules, man. These new laws. A lot of new rules, a lot of new laws. It's a lot of information. Especially for New York. A lot's changing for New York. A lot. So I hope Hannibal is ready for the changes that's about to happen.
I'm never ever ready. It's April Fool's Day. But what's up, Marsha? What's up, Doreen? What's up, Brandon? What's up, Blaine?
A lot of stuff, man. A lot of stuff.
What's up? And nice to meet you, Sheila and Chris.
So, I'm gonna give y'all an overview of what we've been talking about so far. So, New York, the state of New York has passed a new law. This new law is called the Consumer Credit Fairness Act. It's going in effect April 7th, and it prohibits certain debt collection practices. So, you know how, Hannibal, the statute of limitation in New York is 6 years to collect on a debt?
Yes.
After April 7th, it's going to be 3 years.
That's crazy as hell.
Yeah.
For New York, that's
Yeah,
crazy.
it's crazy.
I
So,
hate to be a debt collector, yeah, or to be owed.
so it's 3 years now, and a debt collector cannot sue a consumer on any time bar debt. They can't threaten to sue either. There's no more suing. So if you're in the state of New York, a debt collector cannot threaten you to sue you or take you to court. No. If they do, it's a violation. And the Attorney General is hell-bent on protecting consumers. So the Attorney General, when you file a complaint, they're going to have your back. What else changed? So the 6 years to 3 years, they can't sue. Oh, you know when debt collectors trick consumers into paying on an alleged debt and then it restarts the statute of limitations? Not in the state of New York anymore. Can't happen. There's no reset of the statute of limitations. That's gone. Are y'all hearing what I'm saying, or am I here just talking to myself?
I'm just hoping you're not doing the April Fool's joke. Oh my God.
This is no April Fool's joke, bro. This is law. This is real stuff. You should know I don't have a sense of humor. There's no April Fool's joke here. This is real stuff coming directly from the Attorney General of New York.
You're right. You don't have no sense of humor. How can you make that up?
Can you imagine?
It really was cracking me up when we went to brunch and stuff like that. Like all day.
Like
No,
Flame,
He's just naturally funny because of his accent.
bruh. Do y'all comprehend how consumers are going to benefit from this new law? Hannibal, do you understand the amount of people now you're able to get their reports, bruh, from bad credit to great credit? Chris, Marsha, Sheeta, Flame, Brandon, do y'all comprehend for all y'all clients in New York how much you're able to help these people now?
That's crazy.
Yes.
It's a whole new game changer. YouTube is loving this because right now I'm live on YouTube, Instagram, Clubhouse, and probably Facebook. This is a big game changer. Man, I'm going to take another drink to that. Whew. So, yeah. So, let's do a quick room reset because I've been going almost 3 hours now. Almost 3 hours on my second cup of drink. So FDCPA changes the new rules that took effect November 30th, 2021. The new Consumer Credit Fairness Act that's in place for New York. I think they might even push this to be a federal law. So right now it's just New York state law. But if this goes the way it looks like it's going, this might actually become a federal law. Do you comprehend how everyone in America's consumer report will be changed if this New York law becomes federal law? Complete game changer.
Why are debt collectors not like lobbying against this?
Say again, Hannibal?
Why are debt collectors not lobbying against this like heaven?
Debt collectors have no power, bro. And guess what? The Attorney General is on the consumer's side. It's bad news for any debt collector, bro. So this is a whole new thing. It's, oh man. Dude, when I was reading this, I felt like, yes, we have somebody finally that's standing up for the people. Because the CFPB ain't doing shit.
They're not. No.
Everybody on here knows that the CFPB is not doing nothing. Like, She needs to go apply to be the head of the CFPB. That's what we need. We need her running the CFPB because whoever is there ain't doing shit.
So does the Attorney General have like a personal vendetta? Does she have like, I don't know, $1 million in debt collection or something?
I don't know, but whatever it is, it works in our favor. But from what I've read from the reviews and the comments and the excerpts that I've seen, the Attorney General, the senators, and a few more key politicians, they are all on board with this new law for New York, and they are just going to be crucifying debt collectors.
I kind of feel bad for them because without a villain, there's no hero. You know what I mean?
Why are you going to feel bad? This is an opportunity for you.
No, it's definitely an opportunity, but I mean, like,
Bruh, this is an opportunity for you to fix more people's credit, for you to make more money. Are you going to feel bad for them? They've been ripping people off for years.
it's April Fool's and I'm just playing devil's advocate.
I'm just saying, I'm very excited. I can't wait for the new law to be published because I want to read all of it. I cannot wait to read all of it.
I love bill collectors. Oh my God, they're my best friends.
So, Brandon, imagine...
From the violation, so yeah, I want them to do the wrong thing, right?
Yeah, but imagine the ones now that don't know about these changes, that are not reading and keeping up with current affairs. Imagine the ones now that are violating your clients and what your clients can get now under civil liability, suing these debt collection companies, knowing that the state of New York and the Attorney General and senators are behind them 100%. Do y'all comprehend the amount of power the consumers now have? It's a different ball game.
Game changer.
Game changer. All the states need to be using New York as an example for this. And their attorney generals need to step up. Can you imagine if this went federal? Oh my God.
Yeah, that's gonna be a loaded thing for sure, because that's what usually happens when, especially I feel like California might follow that one.
California joined the fight. If California, Las Vegas, and which other big cities there? New York, Cali, Vegas, Miami. If all the big cities join the fight, bruh, this could really make a difference. A lot. So yeah, I was about to close up shop because we've been on here like 2.5 hours. I feel my voice going. Everyone, the FDCPA masterclass. Oh, don't forget to text the word FDCPA. For those of you who just joined, I did a free overview of the new rule for the Regulation F that came in effect on November 30th. So I have a free training. So text the word FDCPA to 74121 and you will be able to get the link from you'll be able to get the link from you'll be able to get the link to get the free training. It's absolutely free. There's no charge for this. It's an overview. I definitely want to give y'all some information so y'all can start y'all own research. And you guys know I got approved for financing now. So now I can finance people coming into the university. So for everybody that wants to join the university, all you got to do is text the word finance to 74121. Text the word finance to 74121 and you will be able to use my my finance company for you to get finance so you can join the Consumer Law Secrets University. So there's a lot happening, a lot has happened, and a lot is going to happen. And earlier I gave the mods here an opportunity to speak, but for the new mods that came on stage, Flame, can you, for those that who don't know you, Flame, can you tell the people who you are, what you do, and how you can be of service? All right, I guess Flame is not with us. Brandon's on a call. Hannibal, can you tell the people about you, bruv, who you are, what you do, and how you can be of service?
Hannibal. I've never been from Brooklyn, New York, ever in my life. No, I'm joking. I'm Hannibal, I'm the executive director of Finance. We do affordable and effective credit repair, and we really, really want to help people understand financial literacy. We want you guys to have generational wealth. We want you to own homes and businesses, and to do that, you need to have good credit, or excellent credit, rather. And we want you to leverage that and have generational wealth. So if you need anything from us, you can always schedule a one-on-one. There's only 8 more slots, 8 more days this month that I have available to take one-on-one appointments. So book with me at Hannibal10k.com. Book your one-on-one as soon as possible, and I'll go over the 5 factors of credit with you. I'll go over everything that's not accurate and verifiable on your report, and how we can legally remove that stuff. And we have a pay-per-delete option where you actually pay after you get those results. So if you have any questions, the best thing for you to do right now is to follow the club. The next best thing is for you to come up and ask questions. Then you need to text Darain's number, which is 74121, and text finance to that, so you can get some education around what you need to do. Speak to anybody that you feel like you resonate with, whether that's Marsha, Brandon, myself, Flame, Chris, Sheeta, or Darain, or Rose. Take action, because the process is not an overnight process, so you need to get started as soon as possible, so you can reach your goals and be good by the end of 2022.
All right, let's get it. Let's go. See, Flame, are you back, Flame? No. Brandon, no. Oh, guess what, guys? I will be at CreditCon. I am going to be at CreditCon. I'm going to say it again. I will be at CreditCon. So, for everybody that's going to be at CreditCon, your favorite consumer law expert is going to be at CreditCon. I will be in the building.
Okay.
Oh, you heard that part. You heard that part. Okay.
Hey, you already know it, man. Somehow scenario, man, listen. First off, man, shout out to you, Darain, man. I remember this time last year when you said you was going to hibernation to go study. It was
Yep.
this time last year.
Yes, I remember that too, Flame.
Man, yeah, like we forget. We ain't about to forget that. You know what I mean? And he went in, he did his work, he did his due diligence, came out, and struck gold. He struck gold so far that listen, Marsha. I struck gold with Darain in New York City. Like I can't make this stuff up.
I remember that. I remember that picture y'all posted at dinner.
Let me act like I'm lying. I was in New York City. Hannibal. Darain was out there with me in New York City. A host with a few other folks. Man, we ended up tearing up that city in New York. We released
Cinco de Mayo.
Yeah, we released it, and it's on pace. Listen to this, Darain. Listen to what they told me. They said, Flame, by April 20th of this year, La Escuela should pass the school. I said, what does that mean? They said that don't say that word out loud, though. Listen, so what they told me was, by April 20th of this year, that La Escuela should surpass, that's the right word, should surpass the school. So I said, what that mean? They said, that means you will have more sales in La Escuela than the school. I said,
wow.
So you're telling me a person that don't know Spanish can sell more Spanish books of credit than English books of credit? They said, well, we're not saying that. We're telling you that. I said, oh, man, y'all turned all the way up.
Oh, wow. Congratulations, Flame.
Hey, man, listen, that was all part of my man, Darain. Darain helped me get out there, helped me hit the streets. Listen,
Let's go.
Man, y'all gotta know Darain, man. Darain heart really be in the game, man. Real talk, man. Let me put my phone on mute because all I'm doing, I'm over here. Marsh, I'm doing some shit like called blushing and shit. And that's my thing. You know what I'm saying? When you find somebody that got some good information, you gotta turn up for them. You feel
Man, let's go. So,
That's
for those of you on YouTube that's not hearing what my guy Flame is saying, so Flame got the #1 book for credit in Spanish right now. He's the #1. I don't care what nobody says. It's #1 right now for credit. And when Flame spoke about the idea and we masterminded, and then Flame came to New York and we launched this book on Cinco de Mayo in Times Square. Flame is saying it was a year ago, and now Flame is saying that a school reported that the School of Credit is the #1 selling Spanish book right now in the credit space. That is huge. Congratulations to you, King. God damn it. Let's go, Flame.
Man, listen, man, we turn up, we have fun, man. But you gotta surround yourself with great individuals. Man, I seen Rosa Lourdes came in the room. She, 10,000 times she's on a consultation. But you gotta surround yourself. Get in this room right here, making sure that you hit these moderators that's on stage. Have a, oh man, what entrepreneur down there? That's fine. Hey, listen, y'all have a great time, man. I'm gonna tell you this and foremost. Listen, Durain ain't just talking. The information he can say can save you lots of money, and it can make you think about it. If you got a collection on your account that's 5 years old in the state of New York, and it now went to 3 years old. Listen, you get that removed. Oh man, Brown Santa in the room. Listen, oh, this room fire, bro. I don't know how you got Brown Santa in the room.
I don't know. It seems like.
Spit nothing but a rip. Hey, you gotta get Brown Santa up here. He's gonna spit nothing but
Yeah. I'm gonna invite him right now. See, y'all always do this. When I'm ready to go, y'all all come in and then we go for another 4 hours. Listen, this is about to get turned up, ladies and gentlemen. It's been a while, Brown Santa. What's going on, King?
Grandstanding. Man, I just came walking through the neighborhood. I saw a crowd of people standing around, so I decided to stand over and look over the crowd and see what's going on. Saw a couple guys I knew standing at the top of it on stage, and I figured, hey, let me drop by and see what's going on. So I'm glad I came by.
Yes.
Up, how y'all doing?
Well, we're talking about New York State. New York State has stepped up to the plate, King. New York State has just passed a law. It's called the Consumer Credit Fairness Act. And basically, New York is putting their foot down on debt collectors, bro.
That's interesting.
Yep,
Tell me more.
New York has removed the statute of limitations from time bar debt from 6 years to 3 years. New York State has removed the ability for a debt collector to sue you on a time bar debt. They can sue you, they can threaten to sue you.
Hey, Durain.
Talk to me.
Hey, listen. So listen, I just in case if somebody doesn't know, let me alert you. So when it comes to any of these laws, the laws makers got to make them, right? So we understand that part of the procedure, right?
Yeah.
But in New York, y'all got a powerful one. Like I'm not even underestimating this, especially when Kumo got is Andrea, right? So I don't know if you're familiar with Andrea, but Andrea, listen, shout out to Andrea, right? She's basically y'all lieutenant governor who was part of the system. Like I think she was part of the Senate, if I'm not mistaken, right? And what she was doing was early on during the process, she was passing laws. I mean, not passing laws. Let me make that up. I lied on that. She didn't pass laws. What she was doing was implementing suggestions of what some laws should be in order for that to occur, and that's what she did. And so she implemented some of these laws that are effective today. When you're saying these laws are happening, it came from a black woman in order for this stuff to occur.
Mm-hmm.
I wanted to put that on the front street
Mm-hmm.
while everything else is done there.
So I know we have a lot of new people in the room. So Brown Santa, and for everybody that just came in, I'm gonna do a quick refresher. So ladies and gentlemen, as you can see the title, new changes in the consumer law in the consumer laws on debt collection. All right. So I know I haven't been saying it earlier, but make sure that you're following the house at the top. Make sure you're following the moderators. IG, keep sharing this. Share this with 5 to 10 people. YouTube, share this with 5 to 10 people. I know we're approaching 3 hours now. Y'all have been here with me. Definitely share this to whoever you think might benefit from it. And we're going to rock out for probably 20 more minutes. And then I'm going to shut the room down. All right. So I have a free masterclass that I'm giving out. It's totally free. All you got to do is text the word FDCPA to 74121 for you to get access to a free training on the new rules for FDCPA that got put in effect on November 30th, 2021. Now, as it relates to the new debt collection law that's unique to New York State, let me give y'all an overview for everybody that's new, that's just joining. This is coming directly out of Albany. The New York Attorney General, Lilita James, recently sent letters to the largest credit card companies and major debt collectors operating in New York, warning them of new state regulations that prevent them from suing consumers for old debt. A new law protecting debtors, aka consumers, goes in effect in April 7th to be exact. The Consumer Credit Fairness Act of 2021 was signed into law November, goes into effect next month, which is this month, because this article was written in March, and reduces the statute of limitation for consumer debt collection from 6 years to 3 years. For too long, debt collectors used unfair and abusive tactics to improperly collect debts, said Attorney General James. Abusive debt collection practices of the past hurt low and moderate income New Yorkers. The most are burdened them deeper into financial struggles, according to James, who added, I urge New Yorker who feels that they have been a victim of improper debt collection to contact my office. Consumers have rights, and my office is committed to protecting them. Do you comprehend the type of words this queen is using? As of April 7th, 2022, creditors cannot sue or make a threat to sue consumers over debts that are older than 3 years, down from 6 years in most cases. Moreover, any payment a consumer makes after that 3-year period cannot be used to revive the time bar debt. Meaning, if you pay on an account that's over 3 years, it does not reset the statute of limitation. New York, there is no reset of the statute of limitation if you paid on a debt that is over the statute of limitation. That happens no more. This goes in effect April 7th. The Attorney General noted that consumers are cautioned that if they make a payment on a debt that is too old for a lawsuit before April 7th. So remember, I said this goes in effect April 7th. So if you pay on something now that's before April 7th, you will reset the statute of limitation. But if you wait until April 7th, it does not reset the statute of limitations. New York State is leading the pack. Let's go. All the other state, their attorney generals, they need to be following this step. Ladies and gentlemen of the panel, what do you have to say about what New York is doing?
You know I'm going to speak up. Well, first of all, just one little correction. The AKA consumers part, I don't necessarily think that, nor do I agree that they were referring, they meaning the states, they weren't referring to the consumers. They were talking about debtors and people that were in debt, because a consumer is recognized by the federal law as somebody different than what you described there. So a consumer just means a natural person that's obligated or allegedly obligated to pay a debt. So it's always some sort of obligation that you've gotten into for some contract, which you can be sued for at any time, of course. And then it also means that somebody that's allegedly obligated to pay. And I imagine that the federal code is going to be superior to any other state laws, of course, right? In regards to these particular interstate commerce, right? Because whenever you do interstate commerce, it's federal thing, federal jurisdiction. And so I imagine that this whole statute adjustment or state law adjustment probably only has to do with a particular individual that's already in some obligation to pay a debt. Now, there are a lot of strategies. Obviously, we all know that there are strategies that we can employ to rectify any debt or alleged debt. But I imagine that once we all knew the literature that's necessary to enforce our positions, we'd also know that these upgrades, respectfully, don't really matter to the people who know what the consumer laws are, because the consumer laws didn't change. In fact, I mean, Title 15, I mean, we've done this how long now with Title 15? You run up and down Title 15 of the United States Code. I mean, just Title 15, 1692E, I imagine, will set most of the people in this library for free. It'll set them free. And, I always imagine that we believe that some people are in a position. I remember when I started, studying, right? So there's a difference between studying and discovering. To discover is just to bring on new knowledge, and you look at the definition of study means to acquire and then to apply. So you can't study without an application. So since I've been studying, if somebody would have just told me to go to Title 15 USC 1692E, I think that's false and misleading representation. Just that whole, I call it the chapter in that Bible, will set a lot of people free. And it'll start getting people to ask a whole lot of questions, and then it'll start getting people to ask them some questions. And when you start asking questions to debt collectors, some really hard questions to debt collectors start dancing kind of funny. So, there are some people who just don't have the time, right? Because time is its own monetary value, right? Residual energy is our own monetary. In fact, we all trade our time for resources anyway. We everybody, I guess we'll just say money, and we'll put quotation marks around the money word, because we all know what money is. Money can be interpreted into just a resource. If you trade comic books, and that's your money. But I imagine if people knew, if they had an idea what false and misleading representations were, you don't really spend the people for some academic encouragement. And so, like I said, I'll always believe in encouraging people academically. And then sometimes people will run into situations where time is of an essence, and they don't necessarily have time to sit down and acquire the academics that we're going to need to be able to go at some of these alleged debt collectors and these offenders. But if we were to just look in the federal law, and we all know, because look, I know a lot of people, some people in here are well within their academic realm to just know, hey, look, if you go to Title 15, USC, the United States Code 1692E, false or misleading representations, it's a pretty thorough, situation. 16 different codes there, and it's almost like I always tell my friends, it's always like pin the tail on a donkey. Like you take one of those numbers, one of those codes there, and you try to figure out which one of those codes that you might have been invited against. And even if you're just shaking your dice and going Yahtzee, writing it down on the paper and say, hey, look, I got a question. I want some validation on the false representation of services that you rendered to me. So they're going to have to send to you what you asked, right? And so we all know that once you have an open inquiry about something, they can't collect the debt. Because once you inquire about a debt, they are to cease the collection of any debt until the debt's solved. But I just remember that when I first started learning and studying just about 3 years ago, so it'll take long to learn. I mean, it took a lot of hours to put in because of a lot of confusion because of the legalese, of course, right? But I imagine that if we all knew exactly where to go, then we could start working ourselves in a way to where we can start putting it on our own shoulders. Now, I know a lot of people that know this stuff that just don't have the time to do it, and then they come in and ask for different helps and energies. But just wanted to encourage everybody to say that sometimes we want to be able to put ourselves in an academic position so that we can fortify for our own families, you know. So, but yeah, kudos to all the things that's going on in New York. But in New York, they can't stand in the way of the real natural people. We're natural people. We always have been, always will be.
And you brought up an excellent point, Brown Santa. See, this is one of the reasons why the Consumer Law Secrets University is so important. People knowing the laws and using the laws to basically set themselves free. A lot of people don't know or don't comprehend the amount of power that they have. And corporations, debt collectors, debt buyers, some alleged creditor, all of these type of names that they want to give themselves, they come in and through ignorance, and not, this isn't being disrespectful to anyone, but through an absence of knowledge and information, someone that knows the information, they're able to take advantage of you. Is it fair? Maybe. Is it not fair? Maybe. I don't know. The question is, if you're in this room, if you're on this live, if you're on YouTube right now, on Facebook, and you're listening to the sound of my voice, you heard what Brown Santa just said. The laws are there. This is completely something that you do for self. That is why I only teach do for self. The greatest investment you will ever make is an investment in yourself. So I ask you, ladies and gentlemen, when is enough enough? Like, when are you going to say, it's time for me to learn this stuff so I can defend myself? Like, when? Are we going to wait until we lose an arm, a leg, a pinky? Or are you going to have foresight where you're going to recognize that a change is coming and you need to be the educated consumer? The first book I've ever written is called Do for Self, The Educated Consumer's Guide to Repairing Your Own Credit. The reason why it's called Do for Self, because you are doing this for you and all the generations that follow you. You're doing for self, and you will become the educated consumer. That's important. Yes, consumer means an individual. Yes, consumer means a natural person. Debt means an obligation or alleged obligation. Which one is it for you? I can't make that decision for you. Do you know what 15 USC 1692E is speaking about when it speaks about false and misleading representation? When 15 USC 1692GB speaks about validation of debt, what is it really asking? When it talks about a place of abode in location information, and then when Section C under 15 USC 1692 speaks on communication, and it speaks on the consumer have a right to refuse to pay an alleged debt. What does that mean? How do you use that? How do you interpret that? What does the place of abode means? At no point in time, when it speaks about location information, did it ask you for your address. It says the consumer's place of abode. So if a corporation or a debt collector asks you what your address is, well, technically the FDCPA doesn't say you have an address. It says you have a place of abode. So if you don't comprehend these words and use these words, ladies and gentlemen, you will be forever trapped, because they will use their spells against you. This is a game of words. Who knows how to use the word and cast the best spells? That's the reason why I love Harry Potter. The best spellcaster will win. What words are you breaking down? Do you know their terminologies? What they mean? Because when I say person, a lot of people think person means the natural person. It doesn't. It means an individual, but it also means a corporation, a trust, an estate, a cooperative, a government or governmental agency. It means so many other things. Are we really spending the time to learn this stuff so we can teach the kids? So, Brown Santa, you hit on some really, really great points.
I appreciate that. Look, another thing, I was just listening and thinking, and I was scrolling up and down the room, and I see that a lot more people came in since we've been in here. And I just want to offer this piece of a frequency. Another thing, when I first started vibrating at this frequency in regards to dealing in the codification of like the laws, I wasn't a lawyer, bro, and I was like really conscious about going to jail or causing some bigger problem myself into. Okay, now anybody listen to the sound of my frequency right now, I'm gonna tell you, yeah, I was kind of nervous because I didn't want to mess everything up for Olivia, my baby. Like, what if somebody came after me and wanted to put a lawsuit? I don't know how to defend all that nonsense at this time, right? But the one thing I didn't know is that, first of all, you're not going to go to jail. They can't do nothing to you. In fact, the moment you start asking some questions, they have to stop collecting the debt. So let me say this to you again. The moment that you start asking questions to them, with certified mail or registered mail, of course, then they have to stop collecting the debt until they rectify the issue with you.
Mm-hmm.
So do not be afraid to ask a question. Listen, I got people in my realm, right? My circle of friends, and I encourage them, write the Bon Barras letter. Write the letter. Listen, how about this? Write 2 sentences on a paper, right, and head it properly. Send it to them certified mail. But also use some codification to let them know the reasons why you're asking those questions. I'm letting you know that these businesses that are asking you for money, hoping that you don't write them saying, I ain't finna give it to you because the code saying I gotta give it to you, just like a doc said at the top. So you ain't gonna go to jail for just asking a question. Just write a letter down. You ain't even gotta sound proper. Excuse me, why are you charging me this? Send it certified mail and see what happens. I'm being very honest to y'all. Look, a lot of times I sit down and try to be very artistic about my writings, and try to see if I can be as articulate as possible to make sure I conjugate all my verbs and make sure I punctuate the document properly. Get me a grammar text to make sure my grammar is all in point.
Mm-hmm.
All to find out that was just I was smashing a fly with a sledgehammer. Because the moment you put some codification on there and you come supported by the authority of the law, which you really don't have to know that well, because just put it on the paper and send it to them, see what they say. Sometimes they run it, sometimes they won't. I mean, a lot of the stuff that you need at the first level, of the epidermis, you don't really need to do much with it. Sometimes you don't need soap to clean your hands. You need a little bit of water and the hands come clean. I'll back up a little bit and just say that's what it is. But don't be afraid to ask some questions, because sometimes asking questions can be a real hard question for somebody to answer, and they could just do nothing but back up. You doggone credit. I'm trying to tell you. Yahtzee.
I'm gonna give an example. Y'all been hearing me speaking about this collection that I've been waiting on for like the last 2 years. It was an Easy Pass collection, and about 2 months ago, I got a letter from this law firm in New York, and they pissed me off so bad I wrote a whole new letter. I think I made the letter on live. 15 USC 1692E, right? False or misleading representation. It has about 16 questions. 50 Cent says 21 questions. This has about 16 questions that you can ask, whether on a letter or in an affidavit format. I built a whole letter around 15 USC 1692E. Why? Because this letter that I got was coming from an attorney. It was coming from a law office. It's been 2 months and I have yet to receive any correspondence from the office. None. Absolutely none. And I'm still waiting. When you know who you are, when you learn the stuff that I'm teaching in the Consumer Law Secrets University, these are the things that you're going to be able to do. But until you say, self, I recognize that I need to do more. I need to be more. I need to know more so I can protect myself. Until you come to the realization where you need to leave the frequency that you're on and operate at a different frequency, ladies and gentlemen. If you've always done the things you've always done, you'll always be who you've always been. It's not until new information and the renewal of a new mind will new things be introduced in your circle. So what are you saying, Doreen? You gotta learn new stuff. It's important. Why is new stuff important? Well, new information gives you new ways of looking at things. It gives you new ways for you to interpret, analyze. It's new education. My people perish because of lack of information. So how do you close the gap? Learn more stuff. Does it involve mentorship? Yep. Does it involve conferences? Yep. Does it involve getting into rooms where other people are not? Yep. What is investing in yourself worth to you? How much are you willing to invest in yourself to change your situation? So, yo, Brown Santa, you're really spot on tonight, man. I don't know what shot of tequila you took, but you're hitting the nail in all the right places, bro.
Yeah, I took a shot at the Black's Law Dictionary 4th edition, and also took a shot at the Code of Federal Regulations. I took a shot of Peter Pomeroy's 2nd edition of Contract, which is excellent text. I also took a shot. I can continue, but I took a lot of shots today. In fact, I'm taking a shot right now at the U.S. Code.house.gov. So look, are we going to be infringing on anything if we just try? It's Friday, then I imagine you're going to close the room down. But I had a friend coming in from the airport, so I'm sitting in the car just waiting for that plane to hit the ground and so we can get rocking. So if you want, we could. I'm not sure if you have to take your questions, but usually in rooms that I hold, I don't get a chance to get to the chat. But as I was listening to you speak, I was just kind of going through the chat, which is kind of cool. People used to chat, you know.
Oh shit!
I didn't know that. So.
Oh, is this thing in the corner for 49? Damn.
It wouldn't be proper for me to be up here and not ask anyone in here. Are there any questions that might be dumbfounding them?
I have not been looking at this thing, bro.
And due to the nature of the Most High, we got to give away at least 10% of what we're doing to the people, so the people can grow. Because the whole Constitution was written for the people in the first place, right? So, I don't know if it's proper to do it, but if anybody has a question, I guess, now that I'm in here, just for a minute, we could do some batting practice with some real life situations that you may have, so you can see what those things may sound like, so you can help pontificate on how you're going to execute. Or if you're just in a position to where you're like, you know what, you ain't got nothing to lose, you want to see what happens, you send a letter. Hey, let's try and get through that. I mean, I don't know if it's appropriate, but if it is, I'm willing to take some questions.
Yeah, let's help the people. That's why we're here. I'll definitely extend for 15 more minutes. I think we could cover a lot in 15 minutes, and then we'll just close up shop. But yeah, they say YouTube say you're talking real spicy, Black Santa.
Yeah, it's actually brown. Black is
Bro.
black is people that don't have any individual. In fact, blacks are all
Brown
just,
Santa.
yeah,
My correction.
Entities, yeah.
Yeah.
Brown.
So people on YouTube say you're talking real spicy.
Yeah, I don't know. YouTube? You said YouTube?
Yeah, I'm streaming on YouTube, IG, and Facebook.
Oh, so we're doing it like that. Yeah. Well, that's how it normally is, But if we want to take some questions.
Oh yeah, let's get it.
We could do that. Look, and we say we're gonna take some questions. You then got 10 messages since. I think Andrea was vibrating or something in there. She's up here too. But yeah, if anybody has any questions, I mean, we can get as serious as the Uniform Commercial Code. We can talk about contract. We can talk about securities from the Treasury. We can talk about anything. We can talk about the IRS. It's tax season, right? We can talk about taxes. We can talk about IRS. We can talk about how you gonna do your 1040A or your 1099A or your 1099C to be insolvent for 982. We can talk about W8 and WAPN. We can talk about trusts. We can talk about things like 501C. I mean, come on, people. Y'all got business, right? It's Friday. Come on.
All right. So where it came into the questions, is Credit Secrets a good place to start? Credit Secrets. Was that a book? I haven't read Credit Secrets, so I can't give a recommendation on that.
Oh, okay. Well, since you didn't write it, because I know you got like a book out there, I think, I don't know what you wrote, but I want to be like, no, don't do that. But since you say you didn't write it, whoever asked that question.
No, I didn't read it. I didn't read it, so I need to go look what it is. I love to read.
Okay, so, but you didn't author that book, right? Right.
So I need to find out what's this Credit Secret they're talking about, sorry.
Okay, cool. So I would say the best place to start is exactly what we had mentioned before, and it's United States Code Title 15. It's for consumer protection.
Oh, this book, I've read it before. Okay.
My situation is my parents have a reverse mortgage. What should I be looking at to get them out of such a contract?
Ha! That one's easy.
Huh?
That one's really easy. Well, go ahead. That one's wicked.
Well, I have a mouthful.
Shit, let's get it. Let me
Okay,
take a shot. Let me take a shot.
Okay, done.
All right, let's get it.
Oh, I thought you were going to take a shot at that one. Oh, the question.
No, I was taking a real shot.
Yeah, I got some more questions in regards to the reverse mortgage. You know what I'm saying? I mean, specifically, I always ask people, when you ask questions, try to have, the idea of what you want to happen as a result. Because sometimes people ask questions because they don't know what can happen. Then that's a good place to start to say, hey, look, we have this reverse mortgage, and I don't know what can happen in this position. That's a good question. Or because, when you ask, what should I be looking at to get them out of such a contract? My answer would be read the contract.
All right.
For me
So
to answer that question would be immature because I had never read the contract. Hell, it might be a reverse mortgage with a private entity. I don't know that. Or it might be something that it was inherited, right, from one point to another. Hell, I mean, who knows what's going on with the contract? So I never assume a situation is a typical situation. But I'd like to know exactly whomever it was that asked that question. I got my glasses. WC. Particularly, what it is that you want to see happen from that. Okay, that'd be a great way. There, let me scroll down. JJ.
So in retrospect now to that one, right? From my studies and what I'm currently running the play right now and the case laws that I've read, so a new transaction, a reverse mortgage will be a new transaction. So within 3 years, if you have not received your truth in lending disclosures, which more than likely you did not, because if you did receive them, you would have known. There's a section in Truth in Lending, and I think Truth in Lending is the most powerful law ever created. It's called the right of rescission, 15 U.S.C. 1635A, where a consumer, or not consumer, an obligor has the right to rescind any transaction, and any consumer credit transaction, whether it's a new transaction or increasing the balance on a previous transaction. So truth in lending, under truth in lending, you can null and void the security interest in that contract, whether private, federal, whatever, by exercising the right to rescind. This is law. And there's case laws there to back that up. So in addition to what Brown Sanders just said, there's many ways to skin a cat. Just make sure you skin the damn cat. You had something to say, King? Go ahead.
Oh, me? Nah, I'm reading the chat here, going down the list. Best I can here.
It's moving mad fast. Like my screen's just going.
Yeah, this thing here is like a chat thing for real, huh?
I didn't even know everybody could see it. Man, Clubhouse has stepped up their game for sure. All right.
Doreen, you've been behind, but it's been a minute. It's been like that for a minute.
Why you gonna call me out like that, bro?
I'm sorry. So where we at with the questions? I know we did JJ, and I know Tracy was next asking how to delete late payments, how to delete a loan, if that's even possible.
Yes,
But
they're all possible.
yeah, you want to respond to that real quick?
For late payments, 15 USC 1681 AD2A1. That's how you get late payments deleted. That's how you get utilizations deleted. Got the receipts to prove it. Personal loan, if we're talking about just deleting it from the consumer report, we're talking now 15 USC 6802, opt out of having your personal information reported. So that will take care of that part. What else you got?
Okay. So we have, I don't want to say her name wrong. It's Jania Taylor. She's asking, so she's saying she's being sued by a lender for a car. And then she said, I surrendered the car and was upside down on the loan.
Mm-hmm.
The car had issues from day one, and I've been inquiring if I could return it. They lied and said no. They never gave me my right to rescind. They lied in their affidavit. Help.
All right. Does she have proof? So when it comes to sue, this is where that legal part comes in, and I'm gonna let everybody know. Doreen is not an attorney. I do not give legal advice. For this matter, you will need to seek a consumer lawyer, or you learn to do for self. Go pro se. Now, hypothetically, there's a law called Lemon's Law, where if the issue, first we need to find out, was it a new or used vehicle? So if it was a used vehicle, we have what is called Lemon's Law. And if the vehicle has been given issues, known issues, and it's been stated, and it's been consecutive for 30 days, well, Lemon's Law comes into play. So the fact that they willfully withheld that information from you, that is a violation of the law, in addition to truth in lending disclosures that you should have got that you never got. So sounds to me like something could happen. And the fact that you surrendered the vehicle means that repossession is now into play, UCC 9 Part 6, where if you are now owed a balance and they sold it, now we're talking about a repossession deficiency balance, and repossession is its own beast. So there's a couple things sound like it's going on, but I can't just let you know exactly what's happening. But from what I'm hearing, it sounds like you got a few things going on. If any of the mods got any corrections for me or anything to add to that, that could help the queen, that would be great.
Yeah, I got a message here. My little helicopter, my airplane says about I used the right of decision and I lost my house. And I wrote back to how to do it and what right of decision coach used. She said she wanted that mention because she didn't read it properly, and she went into it and all time. So let's go over that quickly here. Please don't say my name. Okay, I won't say your name. All right. So, but I'll just read it. So let me just be very clear about the right of decision here. Just so the right of decision. There are a couple ways that we can enforce that. Okay, so we can enforce the right of decision. With the truth in lending, and I imagine that's like, what is that? 1635.
1635 AF.
Yeah. That's 1635. So here's the thing. With the right of decision in that regard, you can rescind the contract, right? Under the Truth in Lending Act, but you can't just keep the house or keep the car.
Well, yes, you can. So
unless. Okay. So all right. Well, sure. Let's do that. Okay. All right. Tell me how.
So it's not the contract that you're rescinding. You're rescinding the transaction.
Okay, so
now, the law further goes to say that when you exercise your right to rescind now, if it is inequitable to the consumer may retain possession of the item. And
okay, just want to be so until the creditor fulfills any obligation of the subsection.
Wait, say it again.
So that only that's only until the creditor
satisfies the obligation of that particular law. So when the creditor, in accordance with the law, satisfies, then they have to return to the creditor. So
No, they don't have to. They don't have to. So let me go there. Let me break it down.
I'm actually not asking you. I'm just gonna put it up here. 1 second. Hold on.
So under 15 USC 1635, what the creditor has to do is a few things. So I'm gonna just go through it briefly. Disclosures of obligor's right to rescind, except as provided in this section. In the case of any consumer credit transaction, including opening or increasing the credit limit for an open-end credit plan in which a security interest, including any such interest arising by operation of law, is or will be retained or acquired in any property which is used as the principal dwelling of the person to whom credit is extended, the obligor shall have the right to rescind the transaction until midnight of the third business day following the consummation of the transaction. That's one part. The second part says, or the delivery of the information and rescission forms required under this section, together with a statement containing the material disclosures required under this subchapter, whichever is later. So what that is saying is you have 3 days to rescind if you got all your disclosures. If you did not get your disclosures, when you get the forms, whichever is later, in this case, you get in the forms after the 3 days, you are still in right to rescind. Now 1635F caps it at 3 years. Now, all the consumer or obligor has to do to exercise the right of rescission is notify the creditor in accordance with the regulations of the Bureau of his intention to do so. The creditor shall clearly and conspicuously disclose, in accordance with the regulations of the Bureau, to any obligor in a transaction subject to this section the rights of the obligor under this section. The creditor shall also provide, in accordance with the regulations of the Bureau, the appropriate forms for the obligor to exercise his right to rescind any transaction subjected to this section. Now, when we go to 1635B, return of money or property following rescission. When an obligor exercises his right to rescind under subsection A, he is not liable for any finance or other charge and any security interest given by the obligor, including any such interest arising by operation of law, becomes void. So the security interest that was given now becomes void when you exercise your right to rescind. You just voided the security interest that was given in a contract. Now, within 20 days after receipt, how do you prove receipt? Green return receipt, certified mail, green return receipt. After receipt of a notice of rescission, the creditor shall return to the obligor any money, property, given as earnest money. So for those people that bought a house, when you exercise your right to rescind and you put down that down payment, this is how you get your earnest money back, by exercising the right to rescind. If you got a car, this is how you get your down payment back for the car. Or otherwise, and shall take any action necessary to appropriate to reflect the termination of any security interest created under the transaction. So when you buy a car and a home, when you get that title, you're going to see that there's a lien holder. This section now is saying once you exercise your right to rescind, you now need to demand your new title that is free and clear of any liens, because by law, if the creditor has the creditor shall return to the obligor any money or property given as earnest money or otherwise, and shall take any necessary or appropriate action to reflect the termination of any security interest. So that lien that was put on your title, they now need to take that lien off, right? Under the transaction. Now, if the creditor has delivered any property to the obligor may retain. So you can choose if you are going to keep the property, the item, or give it back, right? Upon the performance of the creditor's obligation. So what does that mean is everything that was stated above, determination of the security interest, giving me my down payment within the 20 days of receiving the notice of rescission, giving me my disclosures, giving me the form, telling me how I need to rescind, all of that. The creditor's obligation under this section, guess what? The obligor shall tender the property to the creditor. There's a comma. It says no, except. So the obligor is supposed to tender the property to the creditor, except that if return of the property in kind would be impracticable, or in this case, inequitable. So I can't give up the house. This is where my family, this is where my kids live. I'm not giving up the house. It is not equitable for me to give it up. So the law says if it's inequitable, you may retain it. But there's some things you must do. The obligor shall tender its reasonable value. Tender does not mean money. There's different forms of debt and negotiable instruments. Now, tender shall be made at the location of the property. That's one. Or at the residence of the obligor at the option of the obligor. So it means you can do tender at the location of the property, or you can, so the obligor picks, not the bank, not the creditor. The obligor, the consumer, you pick where and when you want to tender. And the law says tender shall be made at the location of the property or at the residence of the obligor at the option of the obligor. You pick when and where you want to do tender. If the creditor does not take possession of the property within 20 days after tender by the obligor, ownership of the obligor vests in the obligor without obligation on his part to pay for it. Only a court, the procedures prescribed by this section shall apply except when otherwise ordered by a court. So only a court can really kick your right of rescission out the door.
Yeah, so so when you look at 15 USC 1635B, specifically in the section where it says upon the performance of the creditor's obligation in this section, the obligor shall tender the property.
Mm-hmm.
So tender the property. Okay. Now, if we look at the law dictionary, we see specifically that tender is specifically to offer money or anything in satisfaction of a debt or a liability. Now, when there's an equitable title in trust, when there's an equitable title and the equitable title beats the legal title, then the trust is dissolved. So when the person who has the responsibility, the fiduciary, when the fiduciary satisfies and comes on important satisfaction of his obligation, then the trust is no more. It's dissolved. So that's why the individual had to tender her home, or she had to give it up in satisfaction of the debt, because the individuals that she had sued or whatever, wrote these letters to, or to rescind her signature of the contract. And so imagine this for a second. You go sign all these different contracts, right? And then within this law, if it's the way you conveyed it, everybody would just go out signing contracts and then just saying, hey, look, I have a right of rescission, I'm a consumer.
But you can. Every consumer can.
What I'm saying is, clearly here you're seeing the plausible deniability, right? So then the second thing here, just so that upon the performance of the creditor's obligation to this section, the obligor should tender the property to the creditor, except that if the return of the property in kind will be impractical. Well, it's practical because you still have your house, okay? And it's inequitable? No, it's not inequitable, because the definition legally of equity, right, means unjust. Well, there's a judgment, because once you already paid, you're already satisfied. So now it's just. So that's why she wasn't able to keep her house, because it was unjust for her to keep the house. Just means fair. They paid, now you got to get out. And of course, you don't got to pay nothing else. You don't have to pay no finance charge, it ain't that. But you got to get out. Secondly, at the bottom, if you want to go all the way down, let's go all the way down the bottom here. And let's look at where, just because sometimes it says, let me see here, where it specifically will tell you exactly what it's meaning by these particular laws. Let me just scroll down. Rescission arise, additional limitation.
So
here we go. Limitation on rescission. An obligor, that means somebody who's been asked to pay, shall have no rescission rights arising solely from the form of a written notice used by the creditor to inform the obligator of his rights. So what does that mean? That a lot of times people think that just because they write the creditor saying that they don't want to pay, they ain't got to pay no more. It says here that an obligor shall have no rescission rights arising solely from the form of written notice used by the creditor to inform the obligor of the rights of the obligor under this section. Now, if the creditor provided the obligor from the appropriate form of written notice published and adopted by the Bureau, now the moment they put a contract together and you sign it, yeah, unless you point out the actual intrinsic value of it, then they already put you on notice. And it says something or comparable when written notice of the right of the obligor. Any of those that were properly completed by the creditor and otherwise compile with all other requirements of this section regarding notice. So necessarily, this is plausible deniability for any creditor that come out to anybody if anybody just uses the right rescission.
The case law that supports this is the Genowiski versus Countrywide, a Supreme Court ruling.
So let's talk about that. Let's get into that if you like. Let's get into it and see, because necessarily.
So I'm gonna break down the case law. Yeah, I'm gonna read it now. I'm gonna get into the case law that supports what I just said. Those concerns that you raised did come up in this case, and the final decision was the right of rescission is completed upon notice to the creditor. That's a Supreme Case ruling. And stare decisis, let the final rule stand, supports this. So now we're at the Supreme. Dan, listen, y'all are in for a treat tonight. Y'all are lucky. Y'all are really lucky. Bronson is my guy. I only teach this part in my mentorship. Y'all are getting a real treat tonight. So the Supreme Court. So Bronson, if you look up Genowiski versus Countrywide, let me know when you find it. So
Genowiski and Countrywide, I'm actually familiar with, so we can just get right into it.
Oh, okay, cool. So it's 7 pages long. If you want me to go through all 7 pages, I can. Or I could just skip to the end where the conclusion is.
I wanted to show you particularly in Genowiski, but you get your point, and I wanted to see exactly what you're talking about because.
All right. So I'm gonna go to the conclusion.
I don't know if you want to put it up there so in the chat so people can see it. I'm out here walking, like in the chat at the bottom so people can see.
How am I gonna do that?
Right, me personally asking.
Oh, you mean I'm on my computer? My bad. I'm on the computer and the phone at the same time. So, all right. If you, all right, hold on. Let me go and find it here, and then.
There's some academics. There's some academics down at the bottom, and they all just start on text me and the thing here on the box. So I just figured they
let's see, Genowiski versus Genowiski versus Countrywide. Alright, so I'm about to drop this in the chat. For those of you on Instagram, look up Genowiski versus Countrywide. Alright, boom. So I just dropped it in the chat. On YouTube, look up Genowiski versus Countrywide. Nish, if you're here, copy that link that I just put in the chat and throw it on YouTube and throw it on IG. I'm telling y'all are in for a treat tonight. So instead of going through all of it, let's go to the opinion of the Supreme Court. All right, opinion of the court. Where am I going to start? All right, respondents did not dispute that 1635A requires only written notice of rescission. Indeed, they concede that written notice suffices to rescind a loan within the first 3 days after the transaction is consummated. They further concede that written notice suffices after that period if the parties agree that the lender failed to make the required disclosures. So this is contingent upon you not getting your truth in lending disclosures. If you get your truth in lending disclosures, then the 3-day rule apply. If you did not get your truth in lending disclosures, then now you are in for 3 years. 3 years according to 15 USC 1635F. It gives you 3 years. That's the expiration. Now, respondents argue, however, that if the parties dispute the adequacy of the disclosures and thus the continued availability of the right to rescind, then written notice does not suffice. Section 1635A nowhere suggests a distinction between disputed and undisputed rescission, much less that a lawsuit would be required for the latter. In an effort to sidestep the problem, respondents point to a neighboring provision, 1635G, which they believe provides support for their interpretation of the Act. See, Section 1635G states merely that in any action in which is determined that a creditor has violated the section, in addition to rescission, the court may award relief under Section 1640. And if you know, any violation under truth in lending, according to 1640, you are owed double the finance charge of this title for violations of this subchapter, not relating to the right to rescind. Now, respondents argue that the phrase award relief in addition to rescission confirms that rescission is a consequence of judicial action. But the fact that it cannot be a consequence of judicial action when 1635G is triggered in no way suggests that it can only follow from such action. The Act contemplates various situations in which the question of a lender's compliance with the Act's disclosure requirements may arise in lawsuit. For example, a lender foreclosed action in which the borrower raises inadequate disclosure as an affirmative defense. Section 1635G makes clear that a court may not only award rescission and thereby relieve the borrower of his financial obligation to the lender, but may also grant any of the remedies available under Section 1640, including statutory damages, W finance charge. It has no bearing upon whether and how borrower rescission under 1635A may occur. Finally, respondents invoke the common law. It is true that rescission traditionally requires either that the rescinding party returned what he received before a rescission could be effected, rescission at law, or else that a court affirmatively decree rescission, rescission in equity. Now, 2D, Dobbs Law of Remedies. It is also true that the Act disclaims that common law condition precedent to rescission at law that the borrower tender the proceedings received under the transaction. 15 U.S.C. 1635b. But the negation of rescission at law's tender requirement hardly implies that the Act codifies rescission in equity. Nothing in our jurisprudence and known tool of satisfactory interpretation requires that a congressional act must be construed as implementing its closest common law analog. CF Astoria, Fed, Sav, and Loan, ASSN versus, that's a case law. The clear import of 1635A is that a borrower need only, so this is the opinion of the court. So where I'm at now, ladies and gentlemen, is the opinion. The clear import of 1635A. So what that means, they're talking about 15 U.S.C. 1635A under the truth in and in the right of rescission, is that a borrower need only provide written notice to a lender in order to exercise his right to rescind. To the extent 1635B alters the traditional process for unwinding such unilaterally rescinded transaction. This is simply a case in which statutory law modifies common law practice. The Genowiskis mailed respondents written notice of their intention to rescind within 3 years of their loan's consummation. Because this is all that a borrower must do in order to exercise his right to rescind under the Act, the court below erred in dismissing the complaint. Accordingly, we revised the judgment of the Eighth Circuit and remain the case for further proceeding consistent with this opinion. So, ladies and gentlemen, when you read this, you're going to see that Bank of America was saying that the Genowiskis had no ground based on the law, and the final rule is that within the 3 years, all that is needed to complete the right of rescission is written notice. King, if you have anything else you want to comment on this, I'd definitely glad to hear your take on it.
Yeah, I'm sitting right here on the repeated bench. So let's talk about that. So there's a big misconception in this, and what I want you to do, I had a scholar in our group. She sent me something that I thought was great. I'm out here for a walk, and just so everybody knows, okay, when something goes to the Supreme Court, okay, the Supreme Court don't make any rulings. So the Supreme Court does not make any rulings. All right, they only offer opinion. Okay, and so the rulings are made. The rulings are made at the state level. So you can sue somebody in the state, right, and then not get what you want from the state and bring it to the Supreme Court, and they can tell you, nah, we think that the person was right. The state can tell you, forget you, Supreme Court. This is what it is. Okay, so I don't want there to be any misconception. That's an absolute fact. So let's just look at what the common law says here. So the common law, do we know what the common law is? And do we know who qualifies for the common law and who doesn't? So the common law, everybody, is not for everybody. It's not all of you sitting in the room. There's a certain kind of ramification you have to qualify for in order to be within the ramifications of the common law. Okay, so this whole case right here was merely for the individual's right to rescind. It had nothing to do with the equitable interest, because this was not the company suing somebody for the equity of the property. This was just for the right of decision. So here where it says no, it's not going to negate. Let me just go to what she sent me here. She scroll up because I got a lot of messages. I don't know why people don't message you in this group that you're talking to. They message me directly. I don't know why they do that.
There's messages there. I got 5 screens. I can't read through all of these messages. I reply to them after, but there's no way going through all of these messages. YouTube, Instagram, Facebook.
She says the line where it says, but negation of the rescission that laws tend to require hardly implies that the act codifies rescission and equity, right? So you see that? So here it's going to tell you about the negation of rescission law. So here's it's saying there is no law in the jurisprudence tool that's going to be able to negate the code to where somebody can take the property or not. That's left up to who? They can't tell nobody what to do with anything. It's the Supreme Court. They can only offer an opinion.
Mm-hmm.
So they don't deal they only deal in law, bro, common law. They don't deal in anything legal. The legal ramifications are always left up to the states, bro. Okay, so when they're talking about the common law, yeah, common law deals, with the civil situation, family and things like that, right? Judgments, right, at the supreme level. But all the statutory stuff is done on the state level, and whenever the people think that they're being done in an unjust manner, the people will bring it to the Supreme Court. But the Supreme Court may or may not take the case. In this case, they took the case, and they made an order that the person had the right to rescind, because the argument in the case was whether or not they had the right to rescind or not.
Mm-hmm.
So this was not an equitable case law. This was a case law which supports the fact that you can rescind the contract.
Mm-hmm.
And because it was done in 3 days, I imagine this was
Not 3 days, within the 3 years. They did it, yeah.
UCC says 3 days, but this is within the 3 years. So Janoski versus Countrywide, I imagine that this individual had gotten some kind of home loan or something like that, and he had 3 years to rescind the contract, and he rescinded the contract, and Countrywide was pissed, and they told him he couldn't do it just in writing, and he said, I could do it just in writing, and then they said you can't. And so he said that you could, based on the ramifications of the law, and they found out that he could. In spite of USC 1692H saying that wasn't just enough, but you see, this is the key point in this case right here, right? 1635H that we were talking about earlier. I don't know if I'm correct. I'm walking around, so I'm.
No, it's all good. I gotta go really soon too, but I'll go to 1635H. Give me 1 second, King. Let me pull it up.
So let me tell you. Yeah. So basically, that was saying that something about the form of writing is not all like something about the obligor. Them putting something in writing is not all that required. There's more that's required, right? It says something about that, but it says as long as the creditor provided the obligor with the appropriate form. The key fact of this case was that, listen to this very carefully. Go all the way to the top when it first started. I heard you say it, because they gave it to you in the beginning. The key fact of this was the admission of the goddamn creditor. They admitted they had a fault, so they lost up and down, left and right. Had they not admitted and said screw you, they would have lost.
So now,
So they admitted that they had a fault. And so now, because they admitted they had a fault,
and
rare that a company will say, whoops, my bad.
all right. So now, Brown Santa, when you, I'm gonna assume that you have you have a car, right? Allegedly. All right. Now, when you went to get said item, when you were signing those paperwork with like the retail installment contract and all of that, did they give you your truth in lending disclosures?
I did mine a different way.
Oh, okay.
I did mine. I can say how I did it. I don't know if it's from the lobby, but I did mine. Using particular credits from the IRS.
Touche. I need to speak to you about that.
When you're an insolvent individual, you're a natural person.
I completely comprehend.
Live off credits, not the kind of credit we're talking about today.
I completely.
We're talking about the credits that you get because you got blood in your body.
I completely comprehend what you're saying.
Yeah, absolutely. But keep in mind.
That's another conversation. Gotcha.
Whenever we see cases and case laws, we need to see what the actual case is about, and they won't go off the point. They won't go off the point at all. They'll rule the case, or they'll give an opinion on the case on the point proceeding. And the point of this case was the fact that Countrywide was all pissed. We went through this before. Somebody and I, that's how I know the case. So Countrywide was pissed that they used the right of rescission, and they was trying to tell homie that he couldn't use it. And they was trying to make up all kind of reasons as to why he couldn't use it, but they had already confessed that they made a mistake in the beginning. And they didn't know that the mistake was costly for the asses.
And it goes back to the disclosures. And when I ask people, I got this contract. Well, what under truth in lending, because everybody is a truth in lending lender. Did you get all the required disclosures for the transaction? Well, I don't know. Well, the law says the disclosures must be conspicuous. So if you got them, you would have known. There's no way if something's conspicuous, you're not going to know if you got it or not. Unless I don't comprehend what conspicuous means.
Oh, but I got another message. She says, what exactly are the list of items that you're talking about that you're supposed to be given?
So it's written in the law. That's what I keep telling y'all. That's why y'all gotta read this stuff. 1635A tells you every single thing that you're supposed to get. All right. So listen to this. Boom, boom, boom. Midnight of the third business day following the transaction delivery. Okay. Or this part that says or. The part that says or all the way to the end of A is going to tell you everything that you need to get. Well, to 80%. And then when you go over to 1605 under the finance charge, there's more things over there that you're supposed to get. So it's not like there's if you don't know, you don't know.
That's where the confusion is. So let's not skip over that.
Which one?
Let's look directly at 1635A and see exactly where they list exactly the deliverables that they're supposed to give you.
All right, so let me get it. So we know about the 3 business days, right? That's if you get all your disclosures. But listen what the law says. Or the delivery of the information and rescission forms. So you're supposed to get information and rescission forms required with a statement containing the material disclosures required under this subchapter, whichever is later. And it goes on further to say that when you exercise the right, guess what? The creditor shall conspicuously disclose in accordance with the regulations of the Bureau to any obligor in a transaction subjected to the rights. So you need to be also given your rights under the section. They need to tell you what your rights are under truth in lending, right? The creditor shall also, you notice it says shall. It's not may. It's not or. The creditor shall also provide, in accordance with the Bureau, appropriate forms. You're supposed to get the forms for you to exercise your right to rescind, ladies and gentlemen. It is all in their language. All your truth in lending disclosures are written in truth in lending. All of them. The question is, are you reading? Are you studying? Are you doing for self? Because this is not something you're just going to know off the bat. You're not. If you're not in my university, or you're not plugged into Brown Sana or all the other credit expert on here, if you're not in these rooms and you're not reading the laws, the person that knows the most information will take advantage of you.
Well, let's talk about that for a minute, Darain, because there are a lot of questions, unanswered questions in the chat that we probably won't be able to cover.
There's no way I can get to all these
I
questions.
know we probably won't be able to get to all of them, but let's tell everyone how they can tap in and how they can access you through your mentorship, through the university. Let's talk about that and the options that they have available to get started today.
All right. So the greatest investment you will ever make is an investment in yourself. That's number one. I believe that I am worth any investment that I want to take up because I believe in me that much. Ain't nobody here believe in me more than me. I can tell you this for a fact, right? Information changes compensation. Information changes situation. My people perish from a lack of knowledge, a lack of information. Brown Sana is able to speak and articulate himself the way he's able to, through enlightenment, through information. So, what will you learn? What I'm going over now is what I go over with my students in the university. These are things on our Zooms that we are breaking the laws apart. We are reading, we are analyzing, we're finding case laws. We're running the plays. I'm running the play, everybody's running the play. When I told people that utilizations was illegal and shouldn't even be in your consumer report, no one believed me. Doreen, what are you talking about? I got receipts. The law is the law. Utilization is not a factor on your consumer report. It is only a factor on your FICO score. Late payments are illegal. Not supposed to be in your consumer report. Late payment is a factor in your FICO score. Your FICO score and your consumer report are two separate things. Your consumer report is yours. FICO score belongs to FICO, Fair Isaacs Corporation. It is a risk model, a scoring model that takes data from your consumer report to spit out a risk score. They are not the same, ladies and gentlemen. But if you don't comprehend the differences between your consumer report and your FICO, you will think that they are the same thing. Ladies and gentlemen, the definition of your consumer report, no way, shape, or form includes the word FICO in it, or Vantage, or any other scoring model. It does not. So, ladies and gentlemen, you will learn how to break their words down, because when you use their words against them, they cannot say they didn't say it. Did you know there is no law? There is absolutely no law that says any information has to get reported on your consumer report. If someone finds the law that says your information and everything needs to be reported on your consumer report, I will sell you $500. If anyone can find me that law that says you have to report, I will sell you $500. And everyone here is my witness. What is Doreen's point? If you don't comprehend their language, ladies and gentlemen, you will never be able to speak their language. And that is what you're going to learn in the university, how to speak, comprehend, and respond using their language. I know financing was a big thing, but guess what? We just got approved for financing. Yes, we are
approved. Let's go and pin that on the live for the lower bar of the screen so people can see how to tap into that right now before you go for the rest of the night.
Yes, so
that's
if
super
they
important. We've been working so hard for months to get financing and payment options into the university and just for the resources on the website. So it's a big win for us, for the company. So yeah, let's go ahead and pin that so everyone can see.
Yeah, I did. And if you text finance, text the word finance to 74121, you will be able to use this link to see if you qualify for financing. So there's a pre-qualification, soft pull, and then if you get accepted and you good, it will be one inquiry. Yeah.
And you mentioned something about, most people get in success even with like a 500 plus credit score.
Yes. So what I got from the consultation is they approve people up to down as low as a 500, but they have their internal guidelines that they use. So when you apply, it will determine based on your data points or based on whatever your approval rate. But you can make that decision off the pre-approval because the pre-approval is a soft pull and it does not really affect you. It doesn't affect your consumer profile.
Right. Also, based on our research, we found that they pull from TransUnion. So that's good to know as well.
So, ladies and gentlemen, Black Santa, I definitely need to get in contact with Brown Santa. I don't know why I keep saying Black Santa. My bad, King. I need to tap into definitely further discussion you did raise a very important point, and there's definitely something that I need to reach out and speak to you about. And I love conversations like these, ladies and gentlemen. See, it's being surrounded with people like this. Darain isn't always right. Darain doesn't know anything. But guess what? Darain is going to learn from everyone. Darain is taking notes on what the Brown Santa is saying. And guess what? Darain now is going to get educated on something that he didn't know. See, the minute you think you know it all, and you cannot learn from anyone, ladies and gentlemen, is the minute where Darain says, I'm really sorry for you. This thing is a lifelong learning process. There's so much more to learn. So much more. So, Brown Santa, you don't even know the amount of gems you dropped and the amount of curiosity you triggered, King. I really hope you know, bro. So
Well,
thank
I
you.
can tell you this. I can tell you this. Praise the Most High,
100%.
because it take diligence to be able to have a man say he's gonna give you $500 and tell him he can keep it, but you're gonna show him something. So let's go to 15 USC 1681 MD.
Tell me that again, please.
15 USC 1681 MD.
MD.
Duties of users making written credit or insurance solicitations based on information contained in the consumer files.
1 second, King. I'm pulling that up right now. And you said D as in Delta, right?
Yeah, 15 USC Delta.
Got you.
15 USC 1681 M Delta.
Got it, King. So for YouTube, if you're there, 15 USC 1681 M Delta. M as in Mike and D as in Delta. Go ahead, King.
Can you hear me?
Yes.
Doggone thing.
Yeah, you sound different. Your audio sounds much different. Duties of users making written credit or insurance solicitations on basis of information contained in consumer files. In general, any person who uses a consumer report on any consumer in connection with any credit or insurance transaction is not initiated by the consumer. That is provided to that person under section 1681B, C1B of this title, shall provide with each written solicitation made to the consumer regarding the transaction a clear and conspicuous statement that information contained in the consumer's consumer report was used in connection with the transaction. B. The consumer received the offer of credit or insurance because the consumer satisfied the criteria for credit worthiness or insurability under which the consumer was selected for the offer. If applicable, the credit or insurance may not be extended if, after the consumer responds to the offer, the consumer does not meet the criteria used to select the consumer for the offer or any applicable criteria bearing on credit worthiness or insurability, or does not finish any required collateral. The consumer has a right to prohibit information contained in the consumer's file with any consumer reporting agency from being used in connection with any credit or insurance transaction that is not initiated by the consumer. I'm going to read D again. The consumer has the right to prohibit information contained in the consumer's file with any consumer reporting agency from being used in connection with credit or insurance transaction that is not initiated by the consumer. And E, the consumer may exercise the right referred above in subparagraph D by notifying a notification system established under section 1681 BE of this title. King, is there a specific point? I got a few things from here, and this ties back into 15 USC 6802, the consumer having the right to opt out, and 15 USC 1681 C2, where blocking information that arose from identity theft. I got a couple things out of this section. What exactly did you want to bring to light on this section?
Well, you see that any person who uses a consumer report on a consumer in connection with any credit or insurance transaction that is not initiated by the consumer, that is provided to that person under the section 1681 BC1B of this title, they shall provide each with a written solicitation made to the consumer regarding the transaction of the clip. So they are supposed to report anything that they get from you unless that transaction is initiated by the consumer. You see, here's the tricky part. This is why we should be friends. This is what gets them out of that shit. Read C. C says reasonable procedures to assure compliance. No person shall be held liable for any violation of this section if he shows a preponderance of the evidence that at the time of the alleged violation, he maintained reasonable procedures to assure the compliance with the provision of this section. You see, the way they get you is this, and this is why we should be friends. The Black's Law Dictionary will tell you what the definition of initiate is. The definition of initiate is to start something without finishing it. Pretty much, you're going to have to bust a move and actually put a lawsuit on them. You see, because you have a right to. They're telling you that in D, which you read twice, and they're reasserting that in E by telling you that the consumer may exercise the right referred in subparagraph D by notifying the system. So they told you that the way that you have to, they're trying to tell you how to initiate right there.
100%.
See, sometimes we think that we remember what things are, they're not always that. So I encourage everybody to get the Black's Law Dictionary and look at the term initiate.
100%. 1 second, King. 1 second.
Word in that whole sentence. If you don't initiate, then they can just say C, plausible deniability. They sent you all these letters and you ain't say nothing about it, and then they get reported. So they're not in violation for reporting it because you never said nothing about it.
1 second. 1 second. Instagram. I see a timer going. It looks like this live is going to end in 1 minute and 30 seconds. So Instagram, I'm going to repost this. I'm closing out soon. The timer is going. So if after 1 minute and 20 seconds, if it goes away, it means the live ended. All right?
We can kill it. Big vibe.
Yeah. So yeah, boom. Instagram got that. YouTube, we're gonna get some more information to you. But yeah, Brown Santa, we definitely need to connect. This is a powerful statement. And like I told everybody before, you control the narrative. Just read. They'll tell you how to opt out of their system. They're gonna give you all the information. But if you don't use it, then, well, guess what? They do whatever they want. Before your information gets reported, did you all even know that under 15 USC 6802, there is 3 criteria that must be met before any person, and we know that a person means a corporation, can report your information. There's so much y'all need to get spun up on, beloved. So we got less than 15 seconds left on Instagram Live. I'm going to repost the live. YouTube, I'm about to close out. We're approaching 4 hours. Golly.
Hey, thank you, Bab.
Yo, let's go.
Black's Law Dictionary, 4th edition. Somebody asked me for the 4th edition. That's the frequency. All right. I'm going to play around a little bit because I'm still waiting on my man to get off his flight. So.
All right, cool. We're going to connect. All right, King?
So that's the frequency.
We're going to connect.
Let me know.
Most definitely. Everyone have a splendid night. Happy Friday. I really hope y'all learned a lot. Yeah, let's get it. Let's go. I will be answering DMs throughout the weekend. So just know that if I don't get to you tonight, I will get to you throughout the weekend. I will answer DMs. All right. So I'm just letting y'all know that now. So with that said, ladies and gentlemen, have a great night. It was great liming with y'all. I love the conversations. Let's keep it going. Let's go.
Have a good night, everyone.
Yes,
Bye.
yes, indeed. Sheesh, that was a lot. All right, YouTube. Audio is low. Oh, cause he's on Clubhouse. I guess it was the restriction. Boss man talks. Boom, boom, boom. Yep. So, share. It's been a great 4 hours, ladies and gentlemen. It has been a great 4 hours. But now I hear my voice is going. I'm gonna close out for the night, and you'll get more information from me throughout the week. Remember, if you need financing, all you gotta do is text the word finance to 74121. For financing, you're able to join the university. It's going to be great. It's going to be amazing. We're going to get so pumped up. So pumped up. And you know, I'm an island boy. Just trying to make it. I'm an island boy. Where do you start? Go to my website, or you could text the word FDCPA. Text the word FDCPA to 74121 to get the free class. Text the word finance to 74121 if you want financing to access the university. All right. So, ladies and gentlemen, it's been a wonderful night. I'm an island boy. Y'all have a great night.